Presenting the case.
That would be me, Mr. Chairman.
Okay. So Mr. Lane, it'll just be you.
Yes, sir.
All right. And for Mr. Oxendine, who will be presenting that?
Doug Chalmers. Good morning, Mr. Asper.
Okay. Anyone else, Mr. Chalmers, or just you?
Just me, sir.
Okay, excellent. So a couple of preliminary matters. I think Mr. Chalmers submitted a letter brief for a recusal as to Commissioner Thompson. I think it'd be helpful for the commission if Mr. Chalmers could speak on that, Mr. Lane could speak on that, and then Commissioner Thompson can also speak.
Thank you, Mr. Chairman. Yes, we have submitted a motion requesting that Commissioner Thompson recuse himself in this matter. The reasons for the request and the motion are set out therein, as set out in the motion. We respectfully request that it be included in the record of both cases. The motion is both for the 2017 case and also for the 2009 case. The reasons for the request for the recusal are that Mr. Thompson's wife was listed on disclosure reports back in 2009 and 2010 as both the president and the campaign manager of Oxendine working for Georgia, my client's campaign committee. She was involved in the preparation of some of the disclosure reports that are at issue in this case, and we believe that in the circumstances, given her extensive role with his campaign committee, it would be inappropriate to create an appearance of impropriety for Mr. Thompson to appear in the matter. In addition to that family tie, and candidly, I don't know of any circumstances where a judge in this case would sit on a matter in which a spouse or her spouse has played a significant role in the defendant's or respondent's activities. The second is that over the course of the past few years, Mr. Thompson has served as a sounding board for the media, Mr. Salter in particular with the AJC, on other previous hearings of this commission, and has made a number of comments indicating that he has bias against Mr. Oxendine, indicating that he has already ruled, in particular on one of the allegations that's in the 2009 case. Mr. Thompson has already stated his conclusion that the commission staff's complaint is correct. Excuse me. In short, he's prejudged the case based on, without having heard the evidence or the arguments of law. And while that was entirely his right to do that as a private citizen, having done that, I think it would be inappropriate for him to now sit on a panel judging the case. Again, by way of example, I can't imagine any circumstances where a judge in this case would presume to sit on a case and rule on it, having already made public comments to the media expressing his opinions about the defendant or the defendant's legal arguments. And finally, the third ground is that Mr. Thompson was the executive secretary of the commission back when this case was filed a decade ago. We've come full circle and he's now a member of the commission, and in our view it would be inappropriate for a former staffer who handled the case to now be sitting on the commission ruling on it. Under the law, and in particular an Attorney General advisory opinion that was issued back in 1989, Mr. Thompson himself has the authority to rule on this. The commission itself does not have the authority to force him to recuse himself, and neither do we. It's his judgment call. If he remains on the case and participates in it, it's our intent, as recommended by my request, that the motion be included in the record of both matters, to rely on that in grounds of appeal. And I would respectfully request that in those circumstances, and for those reasons, Mr. Thompson recuse himself from the matter.
And one quick question, Mr. Chalmers. In 2015, the commission adopted the conflict of interest policy. Are you familiar with that at all?
I haven't looked at that, but I haven't looked at it recently, no, sir.
Okay. There seems to be a suggestion that there's not a direct consistency between the conflict of interest policy and the AG opinion 89-9. So I don't know if you can opine on that or not, but if not, we'll hear from Mr. Lane.
No, sir, I'm not prepared to opine on that. I think that regardless of the conflict of interest policy adopted by the commission, basic due process requires removal in this circumstance. Whether or not the conflict of interest policy that was adopted by the commission comports with that, I'll reserve my argument to make that later if need be.
Okay, Mr. Lane.
Good morning, Commissioners. With respect to the motion to recuse, Commission staff will take no position on that matter as to whether the recusal should occur or not. The first ground for that being is staff is not familiar with Mr. Thompson's personal relationships and how those may interplay with the Oxendine campaign. I'm simply not in a position to speak as to whether that would or would not be a conflict. Additionally, as to the authority of the commission to remove a member for conflict in reference to the recusal policy that you were referencing, Mr. Chairman, unfortunately, that policy, which was advocated by prior administrations, conflicts directly with Georgia law as well as the Attorney General's Advisory Opinion 89-9. Under both the advisory opinion and under Title 40 of the Georgia Code, a regulatory agency such as ours, an administrative agency, when it is created by statute, only the individual commissioner who has been moved to recuse has the authority to recuse themselves. Under the policy that the commission adopted, that policy sought to charge the chair with the authority to remove a member that refused to remove themselves, or in the event that the chair was the one who was being sought to recuse, a majority vote of the commissioners, not including the chair, could vote to remove the chair. Unfortunately, those policies just conflict with Georgia law, so it is solely at the discretion of any commissioner who's asked to recuse themselves. So, if you have any other questions, I'm happy to answer them, but that's the extent of our
That's helpful, Mr. Lane. Thank you. Commissioner Thompson, welcome.
Thank you.
A request has been made, as you're well aware, for you to recuse yourself, and I want to give you an opportunity to voice your opinion, and if you intend to do so, or
Just 2 points of clarification. One, I was the executive secretary at the time the 2009 case was filed. However, I never reviewed the case. I was never a participant in the case. Under the Attorney General's guidance, because I did have this with a staff member of Oxendine campaign, was to assign it to the staff attorney, which I did. Second of all, to the comment about, or the issue about my comments in the press, I never make a specific comment about an individual, only my opinion of what the law is in a general matter. So there has been nothing prejudged in this because I don't even know the facts. So Mr. Chalmers or his client took it that way. At this time, I'm not inclined to recuse myself. We have 5 commission members. It takes 3 to pass it or to not pass it, to reject it. So I think all fairness will play out.
okay.
Can I address that, Mr. Chairman?
Sure.
Factually, would remind Mr. Thompson of one of the comments that he made here, which he specifically was talking about Mr. Oxendine back when the news stories came out in 2015 and the commission filed amended complaints against him. Mr. Thompson said Mr. Oxendine, quote, thought he was so far off the grid that nobody would notice. That is, in fact, a direct statement about Mr. Oxendine. He has also commented on the legal fees that have been paid in this case. It was not a statement about the law, describing them as the amount of fees paid over a 10-year period as, quote, a ludicrous amount. And to suggest that the statements, with due respect, Commissioner, that you made about the law were not specifically about this case. It was a story specifically about this case on August 15th, 2015, in which you said that, quote, any candidate that designated contributions for a future election and they are not involved in that election absolutely must return every single penny of those contributions. The law states you can't spend that money if you were not in that election. That statement was given to a reporter writing a story about this case. It is a specific statement about one of the allegations in this very case that we're going to be discussing today. So I respectfully would request that those be included in the record as well.
Mr. Chalmers, thank you. And I will note for the record that the commission did adopt the conflict of interest policy previously. The policy did vest discretion the chairman to require a recusal. I think it's clear that that conflicts with AG Opinion 89-9, and I'll just read this briefly into the record, which says, because the obligations of OCGA 45-10-3 are imposed upon each member of the commission, and because the sanctions of OCGA 45-10-4 are imposed only upon a member of such commission, the member of the commission who is the focus of the recusal motion must determine whether his or her continued participation on a particular case is appropriate or whether he or she should voluntarily abstain. So given that language, I will defer to Commissioner Thompson, and he is elected not to recuse and believes that he can maintain impartiality. So we will keep moving forward unless any of the commissioners have a comment or question.
May I make one more comment for the record, sir?
Sure.
Last comment, very short. Mr. Thompson, Commissioner Thompson, excuse me, just recognized or acknowledged that when he was Executive Secretary of the Commission, he recused himself from this matter and assigned it to a different staff attorney because of his wife's role in the campaign. I respectfully suggest that that same recusal policy that you applied to yourself back then should be applied now. Thank you.
Thank you.
Mr. Chairman, I do have one comment. And I want to say for the record that I don't know the history of Commissioner Thompson's involvement in the case. I have no reason to doubt his recitation of the facts and history as he's described it. And I trust that Commissioner Thompson will exercise the best judgment in his mind. I do think for this hearing and for future hearings, I want to certainly put on the record my view that the appearance of impropriety or anything that would cause or cast doubt on the objectivity or the neutrality of members of this commission should always be given the most serious weight, and should be something that should always be taken with great consideration as we deliberate and make decisions. I don't mean to suggest in any way, shape, or form that Commissioner Thompson's judgment in this case is flawed or that I disagree with it. Like I said, I don't know the facts. But on the record, I want to make it clear that in my view, the appearance of impropriety is something that this commission should always take seriously. And I want to make sure that I note that for the record.
Sure. Thank you, Commissioner Barnum. And I think and we all trust Commissioner Thompson, should at any point in the hearing he feel as though he hears a fact that maybe creates a concern on his part, he can always recuse before a vote takes place. But we fully respect your decision, Commissioner Thompson. So moving forward, format of the meeting, and Mr. Lane, this is your case, but my proposal would be you first present your case, Mr. Chalmers presents his opposition, you have an opportunity to reply, and then if Mr. Chalmers has anything limited to rebuttal as to what you put forth, you have an opportunity to do so. It's both for Mr. Oxendine and the committee staff. Is that acceptable?
Yes, Mr. Chairman, with maybe one proviso. To help with since the record will be very voluminous for the commissioners, and to keep from having issues confused, there are basically 3 allegations broken up into 4 parts. What we would submit to the commission is that we would follow your proposed schedule, but we would break up the 3 allegations. So you would hear argument from staff, and rebuttal from Mr. Chalmers, followed by rebuttal from us. And then you would be able to vote as to that allegation. So it's kind of trifurcating, I guess I would say, the proceedings. And that might also help you with the matter of the motion recused, because one of the allegations deals with the 2009 case that began when Mr. Thompson was Executive Secretary. Another one deals with the amendment to that complaint when Mr. Thompson was not with the commission. And then another one deals with the new 2017 case. So that may be helpful and just help from having issues confused.
And then I want to hear from Mr. Chalmers if he also thinks that that's the appropriate way, and then the commissioner has an opportunity to ask some questions.
Yes, sir. Mr. Lane, Mr. Amati, and Mr. Fuller and I got together on Friday, and we agreed that was probably the best and most efficient way to do it.
Okay. Commissioners?
I have just a quick question about the PowerPoint presentation. So this presentation that we have, I believe, maybe we've got a hard copy of it. So is this something that the parties have agreed to as accurately presenting the timeline, the facts, and where there are disagreements? I assume you'll let us know where there are disagreements.
I'm not stipulating to anything with respect to the PowerPoint and the accuracy of its fact. I actually intend to argue that a number of the facts contained therein are inaccurate, and that the characterization of some of the facts are inaccurate. I have no objection to being used as a demonstrative exhibit by Mr. Lane to clarify his arguments. but it is not an admission of the facts contained therein are accurate.
Thank you.
Sir.
Okay, Mr. Lane, if you could first tell us what you're at, so we're going to break the case up into each alleged violation. If you could tell us the first one and then go forward.
Commissioners, just before we begin, and I do apologize for not addressing this earlier, Mr. Chalmers and I spoke before the hearing commenced, and we have stipulated to the agreement that the pretrial motions that Mr. Chalmers raised in 2015, if I remember correctly.
Are we talking just about 2017 now, or both cases?
Okay.
Okay. All prior.
Prior arguments that Mr. Chalmers has made, for example, on the motion to dismiss, the motion to sever, the motion to quash, he would like to preserve in the record his ability to raise those issues at an APA hearing in front of the Office of State Administrative Hearings. We have no objection to him preserving those grounds because that is just how the Administrative Procedures Act works. This is a preliminary hearing. Once the preliminary hearing is done, Mr. Chalmers has the full legal ability to raise those issues once again in front of a hearing officer in the Office of State Administrative Hearings in the final hearing of this matter. So it just prevents us from having to relitigate issues that have already been litigated and that will be litigated once more at the next hearing station.
That's correct. Or that may be litigated in the future that haven't been raised. The sole thing that we're doing today, Mr. Chairman, is we're going to focus on a few very narrow arguments. This case has been going on for a very long time and there's been a large number of proceedings. The arguments that we're going to be presenting from our side today are legal rather than factual, and they're relatively narrow. I don't want that to be construed, and I believe it can be construed as a waiver of any other arguments that we've previously asserted or might assert in the APA proceedings, but I just wanted to clear on the record that the parties have stipulated that that is not a waiver of any other arguments that we do not bring up today, in either case.
Good. I like stipulations between the parties.
Mr. Chalmers and Mr. Lane, will you all be prepared, however, to clarify certain facts, I assume? Right?
Absolutely.
Okay.
And Commissioners, if you will forgive us in advance, we are running two projection systems, one for members of the public so they can see it and one so that you can see it. As Commissioner Barnum has also noted, the commission members have full hard copies because some of the presentation demonstratives can only be enlarged so much before they become distorted and then they have no value. So hopefully that will assist you if you need to look a little closer at the slide. I'm also going to apologize in advance. I will move a little slowly to make sure that I'm at least advancing the presentation equally for everyone. And with that, I'm ready to proceed to our.
But my last point is, I've already spoken to Mr. Fuller about this, if you guys have any documents or exhibits you want to present to the commissioners, Mr. Fuller will get them, and then he'll bring them to us. That way we're not having an awkward back and forth.
Hopefully, the presentation will assist in that matter. Any documentary evidence that will be entered into the record will be done through the demonstrative aid. I have, of course, the original copies that will be entered into the record along with self-authenticating affidavits to show their veracity. But it will allow us to proceed forward. You have it within your packet, so we won't have a delay of having to pass out handouts. Now, if there's something else that y'all would like to see, that can, of course, be produced. But hopefully it will help us in moving along.
Okay. And as I said, Mr. Lane, first give us what the violation, the alleged violation is.
The first allegation,
Not working.
it was just working. I'll blame Mr. Chalmers.
Maybe, Mr. Secretary, if we could get the IT person when we take a recess to take a look at it, and then Mr. Lane, until then, you might have to speak loudly.
I will do my best. Commissioners, the first allegation that we will be addressing before you are listed as allegations 1 and 2 in your PowerPoint presentation, and of course we will advance there after I give you a preliminary summary. The two allegations are that in calendar year 2013, Mr. Oxendine improperly utilized or expended $187,000 in campaign funds which would be a violation of sections 2153 subsection 16(1), 2153 subsection 18, 2153 subsection A, and 2153 subsection C. The sub-allegations within allegation 1 is that there was a $97,000 transfer made by Mr. Oxendine's campaign to his law firm's IOLTA account on January 18, 2013. Another transaction in the amount of $50,000 occurred on February 6, 2013 from the Oxendine Working from Georgia operating account to the law firm's IOLTA account. A $40,000 transaction occurred on April 18, 2013 from the Oxendine Working for Georgia account to the firm's IOLTA account. The second allegation is similar in nature, but it occurs in calendar year 2014. Of that, the allegation is exactly identical to number 1, except it is a $50,000 transaction that occurred from the Oxendine Working for Georgia campaign fund to the firm's IOLTA account on May 30th, 2014. Since the majority of our commissioners are new and have not heard this case, as Mr. Thompson pointed out, I figured a brief discussion of some of the preliminary matters would be helpful for the commission in its determination. This case began on or about April 23rd, 2008, when Mr. Oxendine filed his declaration of intention to accept campaign contributions for his gubernatorial run for governor. As the commission knows, the declaration of intent is the document that gives this commission jurisdiction over a campaign. It authorizes the candidate to begin raising funds and expending funds for their pursuit of higher office. Mr. Oxendine's gubernatorial campaign was for the 2010 general election cycle. Additionally, because of the statute of limitations, as the commission is well aware, any action involving an alleged violation of the Campaign Finance Act must occur within 5 years from the date that those violations are made aware to the commission or are first disclosed to the commission. On April 23rd, Oxendine Working for Georgia Incorporated, that would be his gubernatorial campaign. He had a prior campaign for his insurance commissioner post as well as a prior campaign for lieutenant governor. We are not addressing any of the accounts related to his insurance commission tenure or his campaign for lieutenant governor. We are solely focused on the gubernatorial 2010 campaign known as Oxendine Working for Georgia Incorporated. Additionally, at that time, Mr. Oxendine filed with the commission what is known as a choosing option of separate accounting. We abbreviated at the commission as CUSA. That simply means that Mr. Oxendine has the ability to exceed maximum contribution limits for elections within an election cycle, provided he properly accounts for those funds and then restricts their uses for the various elections that they have been accounted for. And we will go into more detail in just a few minutes on that. Another thing that I would like the commission to note is that in Oxendine Working for Georgia Incorporated, at all time relevance to these cases that you have before you, Mr. Oxendine was the registered agent, CEO, CFO, secretary of Oxendine Working for Georgia. He's the registered chair and the registered treasurer. So there was no other individual, at least on the registrations, were assisting him accordingly. On or about May 11th, 2010, the commission received a sworn complaint in case number 2009-0007 from Mr. George Anderson. Mr. Anderson alleged that the respondent had violated the Georgia Government Transparency and Campaign Finance Act. At that time, it was known as the Ethics in Government Act, but it's the exact same act, just a different name. And the allegation was that Mr. Oxendine had accepted campaign contributions from 10 affiliated political action committees, and that those contributions exceeded maximum contribution limits. On September 18th, 2015, the commission staff filed an amendment to Mr. Anderson's complaint, as we are authorized to do. And in that amendment, the commission alleged, amongst other items, that Mr. Oxendine improperly expended $208,675.51 in campaign funds that he had allocated for elections that he failed to qualify for or that he failed to run in, which would be a violation of 21.543 subsections C and D and 21,533. Now, as far as the figure as to how we came to that number, it was based on Mr. Oxendine's self-disclosed financial reports. During that time, Mr. Oxendine, prior to that new allegation, had been reporting a net balance on hand of about $700,000, $751,869.74 to be precisely. All of a sudden, his campaign net balance dropped to $543,802.23, with no explanation as to where the funds went. So that is how the commission came up with $208,000, because we knew that he should have a restricted fund balance of $751,000 and change, because those were the funds that had been raised for Mr. Oxendine's primary runoff and general election. As the commission is aware, in a partisan election cycle, there are 4 elections in the cycle. There is a primary and a potential primary runoff, a general election, and a potential general runoff. In the 2010 gubernatorial election, Mr. Oxendine qualified for and campaigned in the primary election. Unfortunately for him, he lost the primary, as Ms. Karen Handel and Mr. Nathan Deal went on to the primary runoff, and of course Mr. Deal went on to win the general election. On December 16, 2015, the commission ruled on Mr. Oxendine's preliminary motions. That was a motion to dismiss, a motion to sever, a motion to bar prosecution, and a motion to quash. The motion to dismiss, the motion to sever, and the motion to quash subpoenas were denied. The motion to bar prosecution was denied in part and granted in part. The only allegations I'm bringing before this commission are the allegations that survived that motion to bar prosecution. Any allegations that were granted for the barring and prosecution have been abandoned, and they will not be addressed today, so you do not have to worry about those. On August 15, 2015, the commission staff issued a number of subpoenas to the respondent for bank records related to his various entities, that being Oxendine Working for Georgia, and then of course his law firm's operating accounts and client trust accounts. On October 30th, 2015, it's important for the commission to note that Mr. Oxendine began filing amendments to all of his previously filed campaign contribution disclosure reports. And at that time, and for the first time, Mr. Oxendine disclosed that he had withdrawn $237,000 for what he termed as an investment for the return of interest from Oxendine Working for Georgia to his law firm, John Oxendine, PC. After receiving the new campaign contribution disclosure reports, the commission reviewed those reports and was able to determine that it was likely that Mr. Oxendine had improperly expended those funds, and that is why we filed a new complaint in case number 2017-0169 PC, alleging violations of the act as previously disclosed as to those $237,000. So the allegations still in dispute. And I won't go over allegations 1 and 2 since I've already gone over those with you. Those are relating to the transactions of the $187,000 in 2013 and the $50,000 in 2014. Also explain to you how we calculated it. Allegation 3 will be as to Allegation 3 is the improper expenditure, and then allegation 4, which should be there, will be the allegations in the oldest complaint relating to the affiliated PACs. And we will go into those in more detail. But in essence, allegation 4 is basically saying that there was an $18,800 contribution limit in 2008 when these contributions came in. That'd be $5,900 for the for the primary and general election, $5,900 for each, and then $3,500 for the primary and for any primary runoff. What we have alleged is that the 10 PACs, and we will go into more detail, all provided $120,000 to Mr. Oxendine. So we obviously allege that it violates 21,541 and exceeds the $18,800 then maximum contribution limit. And since we have
Commissioner Watts has a question.
Just so we're clear, so allegations 1, 2, and 3 Right, but my question is allegations 1, 2, and 3 are the 2017 case.
That would be correct.
And allegations 4 are the 2000, what's left from the 2009 case.
That's not entirely correct. I apologize, Commissioner Watts. 1 and 2 will be case number 2017. Allegations 3 and 4 are the 2007 case. Allegation 3 is the staff's amended complaint. And then number 4 will be Mr. Anderson's third-party complaint as amended by us. So it's not purely his complaint. It has been modified by staff.
Okay, and so first we're going to hear 1 and 2, and then 3, and then 4.
Yes, sir.
Okay.
You'll have 1 and 2, we'll take a break. Mr. Chalmers will be able to address his issues with allegations 1 and 2, and then the commission, if you choose, will be able to vote if you prefer, and then we'll proceed forward to 3, take a break, and then proceed to 4.
So repeat that again, Mr. Lane.
Sure, I'm sorry.
Allegations 1 and 2 are from the 2017 case?
That is correct, sir.
Allegation 3 is from the 2007 case?
Correct. From the
And then
amended
allegation 4 is?
2007. And can y'all hear me okay? Because I can go louder. Okay. Since we do have some new commission members, we do have a definitions section. Trust me, I do not intend to read them to you because most of them you already know. But there are a few that would be helpful in just basically understanding the different terms, especially when we get to legal argument, because as I've kind of described to members of the public, the Campaign Finance Act isn't just simply a rule book. It's kind of like a double helix that turns in on itself because it constantly refers to itself in various codes. So to find a violation of 21.541, you have to look at a number of subsections and then refer back to 21.533. It's not as simple as some criminal law statutes, and I've jokingly told this to Mr. Amati, it's not like you look at the armed robbery statute and you don't get to the bottom of armed robbery and say, look to aggravated assault to figure out if armed robbery occurred. But in the Campaign Finance Act, you do. So that's one reason I'm being a little pedantic, and I'll apologize in advance for it. The first definition to really look at would be connected organization, which is the first definition on this slide.
So just to clarify,
Yes, sir.
Mr. Lane, are we just focusing on 1 and 2? Are we
Just
doing-
1 and 2 at this point.
Okay.
Connected organizations, any organization, including business entities, labor organizations, membership organizations, which are not political action committees, as defined by the code section, which is defined in 2 different spots, which provide 40% of the funds of political action committee for calendar year 21, and it's pursuant to 21.53, subsection 6, which 21.53 is our definition section. The next slide simply just shows what an election is, what an election cycle is, and what an election year is. An election cycle for a gubernatorial run is a 4-year period of time. The election cycle begins after an election and it proceeds till the next election. The reason to know that is simply because maximum campaign contribution limits are for an election cycle, not for an election year. So you get one limit for a 4-year period when you're running for governor. Now, just by way of full disclosure, the commission did raise contribution limits in 2009, but the allegations that we will be addressing occurred before 2009, so the lower contribution limit actually applies. In the next slide, the most important thing for the commission to note is the definition of investment in the Campaign Finance Act. The term investment is defined by the Campaign Finance Act as the investment of money or capital to gain interest or income. And trust me, we will be talking about that in more detail. You've also heard us at other hearings talk about ordinary and necessary expenses. Ordinary and necessary expenses by the commission have been defined by law as any expenditure needed to pay for qualifying fees, cost, rent, lodging, equipment, travel, advertising, postage. But it also has a catch-all, and it's anything that can be contemplated by the candidate to advance their ability to seek office or to execute the terms of their office. To make it a little more workable, the commission has informally adopted a but-for test. And the question the commission always asks is, would the candidate incur this expense but for the fact that they're running for a campaign? For example, if a candidate said, I've bought all of my meals out since I won election. That would fail the but-for test because a candidate would eat food whether they won or lost the election. However, if the candidate is renting an apartment so they can attend the legislature and they're coming from Albany, the commission has determined that that short-term rental would not occur because they wouldn't be taking that rental but for the fact they are elected official having to come to Atlanta during session. That's just a quick example of what the before test looks like. Now, as far as the Campaign Finance Act, what are candidates required to do? They are required to maintain records and file disclosures with the commission. They're required to deposit campaign contributions into a depository account that is separate from their personal assets. They cannot commingle funds. So if you're running for governor, you better have a gubernatorial account that is separate from your personal funds at a bank, no commingling. And also, a candidate may have more than one campaign account for separate accounting, but that's not required. You're actually allowed to do sub-accounts within your primary account. So you have one account at the bank, but then your book ledger should be a primary fund, a primary runoff fund, a general fund, and a general runoff fund. And then just as I previously said, the contribution limits are a little funky in this case because the commission did raise it in the middle of the election cycle. The ultimate 2009 contribution limits were $6,100, $3,600 for primary elections, general elections, and the runoffs respectively, so a total of $19,400. As I've discussed, the limits in place at the time of the alleged violations that you will eventually be hearing were $5,900 and $3,500. As far as allegations 1 and 2, this is where we get into the meat of allegations 1 and 2. The main question is who owns what in a campaign account? And the answer is that the campaign account owns all of the funds. The funds in the campaign account never become the personal assets of the candidate or such public officer. And that's pursuant to 21.533 subsection C. That is probably one of the few code sections in the Campaign Finance Act that is black and white. It doesn't refer to multiple different code sections for you to figure out what it means. It's pretty clear. And additionally, 33, subsection A, 2 subsections up from C, also reiterates, as we discussed, that you have to use ordinary and necessary campaign expenses out of your campaign. Now, one thing that's not addressed in the Campaign Finance Act is the definition of what is an asset. Now, as commissioners know, statutory construction, you're supposed to give a meaning to words that are in the normal common parlance and assume that's what the legislature intended. When you look up what Black's Law Dictionary says, a personal asset is defined as an asset in the form of money or chattels. Just plain asset is defined by Black's Law Dictionary as an item that is owned and has value, and all the property of a person, especially in a bankrupt or deceased person, available for the paying of debts or for distributions. And that'll become important because one of Mr. Oxendine's defenses is that the transfer of funds from his Oxendine working for Georgia accounts to his law firm did not constitute personal assets, that they were a loan. Now, what is also interesting for the commission is what's the difference between a loan and an investment? Because the Campaign Finance Act defines what an investment is, but then never really references it again until you get to 21.5.16.1. And in that one, it's describing a disclosure that's required. And in that disclosure that's required, it says that any investment made with funds by a campaign committee, on down the list, are to be held outside of such committee's official depository account during each reporting period. You have to disclose those. You can't deposit money in an investment account and only report what in your operating account. You have to tell us both. And we have a section in the campaign contribution disclosure report that will allow a candidate to show what that investment is, what the profit and loss is. And that's the important distinction I want the commission to make, especially in this case. At the very end of that definition, a candidate is required to disclose any profit or loss from the sale of such investment which occurred during such reporting period. Now that's important to note because it's not talking about a loan, it's talking about the campaign going and buying an investment. So for example, the purchase of Coca-Cola stock by Oxendine working for Georgia, and I shouldn't pick on him, but that would be authorized. because the campaign would hold title to the Coca-Cola stock, and it would be entitled to all profits and losses thereto. So if a gubernatorial candidate purchased Coca-Cola stock with their campaign fund, and it's titled in the name of the campaign fund, and let's say they bought it for $100, and 5 years later when they're ready to run for office, it's worth $10,000, that's perfectly fine. That doesn't violate the maximum contribution limit. They just did prudent investing. And the same is also true if they bought it for $100 and it's worth $2, they've lost money, that's their problem. It's not considered a personal asset, it's not personal gain, it's not personal loss, you can't put it on your taxes, there's no carry forward, it's just a pure campaign investment. You didn't have that in this case, and we'll go into that in a little more. The transactions that were made by Mr. Oxendine were personal transactions. He used his law firm as a pass-through in order to transfer funds from his campaign to himself. The law firm is just a convenient shield. And also, please note that within the Campaign Finance Act, the term loan isn't defined, and it only appears in the Campaign Finance Act in 2153, 30.1, 34, and 41. And that's related to, it's telling candidates that they have to disclose loans that their campaigns took out. So for example, if a gubernatorial candidate, sorry.
I'm going to stop you just 1 second because I think I can anticipate one of Mr. Chalmers' arguments is that.
Sorry, can you hear me? I think I can anticipate one of Mr. Chalmers' arguments is that in this case, isn't it true that there was actually interest that was repaid on the loan, which I guess that's how he characterizes this as an investment because they actually made money on the transaction. What's your response to that?
My response to that is that the Campaign Finance Act does not authorize a loan. There's a distinction between a loan and an investment. An investment is actually the purchase of an asset for the purpose of it creating income or an interest. And you kind of preempted me a little bit, and I'm glad you did.
Sorry.
No, you're good. Questions are great. I like them. An investment is defined by Black's Law Dictionary, G. Is defined as an expenditure to acquire property or assets to produce revenue, a capital outlay. So it's like buying Coca-Cola stock, or it could be as simple as buying a money market mutual fund. That's perfectly acceptable. And the reason the legislature adopted those rules is because when the Campaign Finance Act and its previous iterations came into force, inflation rates were enormous. As I'm sure some of you may know, in the 1980s, interest rates were approaching 15% because inflation was high. So you had to move your money out of a checking account or you're going to lose a lot of your purchasing power to inflation. So the candidates at that time would put money in treasury bills, they would put money in other investments to try and preserve that purchasing power. That was perfectly fine. Since interest rates and inflation have gone much lower, it's not as common to see investments done by candidates. It's very rare. And that's the reason. Now, a loan is also defined as Black's, and this is a distinction that I'd like the Commission to notice, that it's the act of lending or a grant of something for temporary use. And it's generally for the sum of money lent or interest. So you're not giving up title to it. It's simply being personally transferred and you're going to send it back. In this case, I want the Commission to know there are no loan agreements for any of these transfers. There's no promissory note. There's no agreement for a return of interest. There's no agreement as to a rate of interest. There is no timetable for its return. There's no maturity date. There's no balloon payment schedule. There's no monthly itemized schedule. There's nothing. It's just Scout's honor, I promise this is a loan.
Okay, and I think Commissioner Wise, go ahead for that.
So the problem I'm having is that we're talking about Black's Law's definition. Can you get back?
Sure.
Page you're just on. Black's Law's definition for investment, but investment is defined
It is.
in the code. And that definition is the investment of money or capital to gain interest or income.
Correct.
It's not Black's Law
No, it's not Black's Law
definition at all.
That's right.
It looks a lot like Black's Law's definition of loan.
Correct.
And so I guess I'm not really seeing the distinction that you're trying to make, which is the difference between a loan and investment, because here it looks awfully the same if we're just apples to apples what's defined in the code versus what you're defining through Blackstone.
Mr. Oxendine will make the argument that it's an investment or a loan, depending on how it suits him. Because as you'll notice, loan does not appear anywhere in the campaign code except when it's discussing loans that the candidates receive from banks, third parties, other members. It's not going from the campaign to others. There's no authorization within the code that says Oxendine working for Georgia can loan money to third parties. It does authorize the purchase of investments, which have to be titled in the name of Oxendine working for Georgia. That's the distinction I'm making. Now, if you look at...
Where does it say it has the last piece? It has to be titled in the name of the campaign.
If you look at 21.534 subsection B1F, and just go
Is that
back.
on the-
It's on PowerPoint, it's up on
right.
the screen. It's the one at the bottom. Last sentence. Any unprofited loss from sale of such investment which occurred during such reporting period. It's what the campaign is reporting its assets to be, not what someone else is reporting their asset to be.
21.534B.
B1F, yeah. And that's just in the, 21.534 has a lot of requirements, but subsection B is detailing what a campaign must disclose in its campaign contribution disclosure reports as to its assets. That's the only other time you see investment popping up besides its definition. Because you get the definition of investment, and then it appears once again in 21.534 B1F, and then you don't see it again. And it's simply disclosing what a campaign must disclose its assets are. So that's my argument for that it needs to be titled in the name of the campaign, because it's also in relating to 21.533C. You cannot make campaign assets your personal assets.
All right, well, now that we're talking. So the
Unfortunately, I got to read them together.
no, I hear you, but let's just talk about personal assets. So the, I forget the name of the law firm, Oxendine PC.
Sure.
Let's just call it that. Why is that his personal asset?
Because you're going to see when we trace the money, which is coming up, the money goes from Oxendine working for Georgia. It's parked in the IOLTA for all of maybe a day, if that, and then it immediately transfers into personal assets that he purchases from the IOLTA.
Okay, thank you.
Commissioner Varner? And then to follow up on Commissioner Watt's question. So the question was, why is the Oxendine money, the money transferred from Oxendine to Georgia to Oxendine PC, why is it his personal asset? Is there any dispute between the parties that the money that was with Oxendine PC remained campaign assets during the time that it sat in the IOLTA account or any other accounts that were controlled by Oxendine PC? Is there any dispute between the parties as to whether or not that money, while it sat in those accounts, were actually campaign assets or owned or controlled by the campaign?
I believe, and I don't want to speak for Mr. Chalmers, but the discussions we have had is that Mr. Oxendine will maintain that title remained with the Oxendine working for Georgia, that it was a loan, that it was for the return of interest, a repayment of interest, and that it was eventually repaid.
So, Mr. Chalmers, just to preview my question, you don't have to address it now. So I'm going to want some clarification on that. I'd rather you not, because I want Mr. Lane to finish, but I want to hear from the Oxendine campaign why that particular, while the money sat with the Oxendine law firm, why and how it remained campaign assets or funds or title to those funds remained with the campaign.
Would you like me to address that now, sir, or later?
No, later. I'm just previewing the.
No, that is a main part of our argument.
Okay, thanks.
Yes, sir.
All right, Commissioner Thompson.
So just for clarification, these funds went into my IOLTA account, which is a lawyer's trust account.
Yes, sir. It stands for Interest on Lawyers Trust Account.
Okay. Is there rules that how that interest can be used, or can anybody give money to a lawyer account to draw interest on?
Yes, Commissioner, there are rules. Those rules are outside of this commission's jurisdiction. They are proclamated by the State Bar of Georgia. The State Bar of Georgia requires, and of course this is not verbatim, so please, I hope no one reads this and follows my advice on IOLTA management. But basically what the bar requires is that the funds that you put into that IOLTA must be client funds, not your personal funds. The bar has ruled that you can put a minimal amount of money into your trust account to ensure that, like for example, if you're trying to avoid a bank fee, like a monthly minimum $15, you can put in enough money that is your personal firm money to avoid that fee or to cover minute shortfalls, like you have a rounding error. So that's permitted, but you're not allowed to commingle your personal funds or your firm's assets, the operating cash. You're not allowed to commingle that with client funds. Additionally, Mr. Thompson, or Commissioner Thompson, for the interest that is generated by that IOLTA account, that interest belongs to the State Bar of Georgia, and the bank takes all interest generated from those funds and immediately transfers it to the State Bar of Georgia, who uses it for indigent defense, the Legal Services Corporation of Georgia, on that list. So the law firm and even clients don't receive that interest.
So is that part of your argument that it's not an investment because the interest shouldn't be coming back to the campaign if there's rules, even if it's outside of the commission?
It is part of the argument, but the stronger argument is that when Mr. Oxendine first revealed these loans to the commission, he said this is an investment in my firm. And when we actually got the bank records 3 years after our subpoena was issued, none of the money was used as an investment in the firm. There was no purchase of computers, there was no payment of payroll, there was no payment of additional staff, there was no move to a nicer Class A office space. He was already in Class A office space, but he didn't move to like the Atlantic Tower. There was no visible transfer of those loan assets into the operating account, with a few exceptions, for the purpose of general corporate expenditure. When that's pointed out, the argument has changed. Well, we loaned money to the law firm, and then the law firm loaned it to the other third parties to pay us back. And then the argument changes again of, oh wait, all of those loans failed, and might be grossly
And Mr. Lane, we may be, the commissioners,
Correct.
with all of our ingenious intelligence, I think are foreshadowing what you're about to say. So if you would just, how much longer is your presentation?
I'll speed it up.
No, I'm just curious. No, I just want to, if you do that, and then maybe if the commissioners can then
Absolutely.
start asking our questions, that way.
I'll go a little
it's-
faster because the bulk of what's coming up next is the tracing of funds.
Sure.
So that you can see that it's not investments, at least in the firm. What you have next is the first transaction, which was on January 17th, 2013, the $150,000 transfer to the, Oxendine Working for Georgia transferred $150,000 from its money market account and moved it into its operating account. And then on January 18th, it moved from its operating account $97,000 into the IOLTA. That is the first loan that is recorded. Now the section on the side, just to explain it so I don't have to do it each time, I'm showing that you're looking at Oxendine Working for Georgia's bank balances between that period of time. I want you to see that it was not an active account. It was not paying for campaign expenses. The campaign was long since done. There were no insurance payments, there were no tax payments, there were no yard signs. So everything you're going to see coming out are transfers of cash to Mr. Oxendine's PC, with a few exceptions. And on this, you're going to see it's not a pure $97,000. The accounts earned interest. So that's why you're seeing the difference of $96,892 got interest to cover a little bit of the transfer. What was that first $97,000 loan for? It was for a check that had been issued on January 12th, 2013 by Mr. Oxendine to Coldwell Buckhead Residential for deposit on house. And you have a copy of the check in your presentation. As I previously said, there's no loan agreement, there is no agreed upon interest rate, there's no payment reschedule, there's no balloon payment schedule, there's nothing. Now, what house was purchased? It's Mr. Oxendine's primary residence located in Fulton County. Picture which you have now. You also have another view of the investment that the law firm made for Mr. Oxendine. You also have a copy of the warranty deed. The warranty deed and the security deed were issued in the name of John Oxendine in his personal capacity. The law firm did not buy his house.
So hold on one second. So,
I'm sorry. I do apologize.
So the warranty deed was in whose name?
Correct.
In whose name?
Mr. Oxendine, John W.
Personally?
Personally, John W. Oxendine.
Okay.
The security deed is also only in his name, John W. Oxendine. Also confirmed by Fulton County's PT 61. If you're not familiar with real estate closings or divorce work, the PT 61 is a nice little condensing of all of the transactions related to a real estate sale. It clearly shows that the person purchasing the real estate was John W. Oxendine. The purchase price was for $965,000. $96,000 plus dollars came from the check directly from his IOTA. And then you can also see, I'll remember to advance, in the security deed, the actual purchase price that was financed was $723,750. So there was a down payment of $241,250. The total transferred by Mr. Oxendine from Oxendine Working from Georgia to the PC over this period of time was $237,000. The second transaction occurred on February 20th, thereabouts. February 6th, February 6th, there was a $50,000 transfer from Oxendine Working from Georgia to the IOTA account. $25,000 of that amount went from the IOTA to a client who we're going to refer to as AHB. Just so the commission knows, any potential clients of Mr. Oxendine have been redacted from this presentation. I didn't feel it appropriate to put them in there. If you want to know them, they can be revealed, but I didn't feel it would be appropriate at this juncture for them to be revealed. But there was a $25,000 transfer to that client out of the IOTA. And the next advance will show the 3 checks that are related to that $50,000. The question we had was, what was the $50,000 used for? It's a loan to the law firm. What's the law firm using it for? There were 3 checks that totaled approximately, if I recall correctly, about $42,000. One of them is listed to John Oxendine PC with the memo note Valley. We have no idea what that's for. It might be a client, it might be a personal use expense. $12,000 was transferred to Oxendine Insurance Services, which, if my understanding of the corporate records is correct, that is Mr. Oxendine's consulting service. And if you note in the memo field, it says fee for Tanzania. We're not entirely sure what that is. Could be a safari, but I don't know if they're making investments in Tanzania. And then, of course, the last check is loan to AHB, which is a client. Now, just so the commission knows, the client AHB made regular monthly payments to Mr. Oxendine before this loan and after this loan, and the payments didn't vary. It almost looked like retainer payments or like flat fee, flat fees that were going forward. They didn't vary, so it's not like all of a sudden AHB started making payments to Mr. Oxendine after the loan. Their payments to him never changed. The next slide, which will be fairly quick, just like Oxendine Working for Georgia, we tracked the assets of Oxendine PC based across its 3 accounts. Oxendine PC had a money market mutual fund, a operating account, and then it had its IOTA. What we're showing is that basically the fund balances generally don't change because they are just pass-through entities. You will see these transactions are either immediately transferred out of the IOTA to something else, or the next day they are transferred. And that's why we're showing you that his use of those funds never changed on a monthly basis. It's not like his firm was suffering a cash crunch and needed new funds to be able to continue operating. Also, please note that on February 14th, the Oxendine PC transferred $158,000 by wire. That might also explain where the purchase price came from, because it is...
Commissioner Watts.
Yes, sir. Very quickly,
Yes, sir.
we talked earlier about what's in dispute is basically the law. So
Correct.
is the routing of any of these funds, is that in dispute? I mean, because we can read this, but I want to get to the real meat of what we're talking about.
My understanding is that Mr. Oxendine was not prepared to stipulate the routing and the titling, but I could be wrong, that may change.
Well, and I am interested in the routing of the money and where it went. So this is helpful for me.
I promise you, we're
No, you're fine. Listen, it's a I don't want you to rush because it's a lot, all of the commissioners have prepared for this, I know, but it's a lot of information in a short period of time, so.
And after explaining this one, I'm not going to show you the monthly fund balances. We're just going to stick with the tracing of the actual payments. But this way you have the information just to show that it's backing our argument that it wasn't used for law firm purposes. It was just a pass through of the account. You now have the, should be last payment in 2013, which is the $40,000 transfer to the IOLTA account. Where did that money go? It went to a entity called Kathmandu Collections Triple LP for the purchase of 2 units. Kathmandu Collections Triple LP is a debt investment firm. There we go. Where you can purchase, I would assume, medical debt or other forms of debt, and then you get the accounts receivable. The reason this is important is because at no time can the commission find in any of the 3 Oxendine PC accounts any payment from Kathmandu Collections or from other debt holders for those accounts receivable. So we are left with assuming, with the available evidence we have, that it's a personal asset that was purchased. It went into a personal account because no repayments for this investment ever found its way back into the law firm. As comments, I will see that. Another transfer that occurred on May, now we're into 2A, which is the 2014 transaction, there's just one. And for the $50,000 that was transferred into the operating account, it went in on May 30th, and then it left $10,000 on May 30th to the operating account, and then a number of checks were done. And of course, as I said, these accounts have been redacted just so you don't see who the clients are. But at the time of May 2014, the IOLTA Trust account had $31,000 in change. A transfer out of the IOLTA was $10,000, and Mr. Oxendine wrote checks of $44,000. It left a client shortfall in the trust of $12,544. Now, I'm not standing here saying that these were client funds that were transferred. I'm simply saying we can't identify who these entities are. We don't know whether they're clients or whether they're personal asset transfers.
Well, I think you're saying that they were not client funds.
Yeah, I mean, it's just one of those, if the defense is that it's client funds, the question is...
Yeah, we would identify.
Correct, yeah. Now, there are a few of these checks that we can clearly see are clients, because they have, it'll say retainer, like in prior checks. But you have that $12,554 shortfall. I believe Mr. Oxendine is going to say that these are personal asset transfers and not client transfers. But I'll leave that to him to discuss. All we know is that there was a shortfall in the account until such time as monies were transferred from his campaign into the IOLTA account. Now, how is the money invested? As we said, it's $237,000. Total amount of interest earned during the 16-month period we've covered thus far, $0. No payments of any kind from this investment to Oxendine working for Georgia. Now, what's also interesting during this period of time, and you should have the transactions up, on July 21, 2014, Mr. Oxendine sells his Gwinnett County home, and he deposits the $290,000 plus sale price into his IOLTA. Now, what's interesting next is that he writes a $20,000 check to himself, and then he transfers $200,000 into a personal brokerage account at Oppenheimer. I bring this up, Commissioners, because at this point in time, he has the ability to repay with interest the loan that he's been giving from his campaign to his PC. He chooses not to repay it. Instead, he transfers it to further personal assets somewhere else. It does not go back to the campaign. But at this point, no one's brought up the issue that there have been monies that are missing. So that's interesting to note. As far as what were the monies used for is kind of a broad look at the forest. I have 2 theories. The first theory is that the first $96,500 payment, as you saw, went directly for his home down payment. There were also IOLTA shortfalls of $26,122.54 and $12,544.42. So those monies were covered by campaign funds. And then there's the $40,000 purchase for 2 units at Kathmandu Collections, which gets you to $175,166 and change of the $237,000. That's 73.9% that we can clearly show went to personal assets. The remaining $61,833, or 26%, my apologies, it's either used for subsidizing lifestyle or it was used for personal assets in theory number 2. For example, during this period of time, Mr. Oxendine made a $12,250 deposit to his self-employed person in the IRA. He made $27,476 worth of payments to the Atlanta Athletic Club, $12,671 in payments to the daycare for his minor child, and $31,602 for vehicle payments. Now, the vehicle payments, I know, can be argued are legitimate business expenses. That is, I'm sure if anyone on the commission is doing that with your business, you only get one car that you can deduct as your personal perk. You can't have 2. Mr. Oxendine had 2 during this period of time. He had a Mercedes-Benz and a Jaguar, and he broke the lease on the Mercedes-Benz shortly thereafter because he was paying approximately $2,000 a month. So one of them correctly could be called a business expense. The more I thought about it last night, alternative theory number 2 is the most attractive to me. Because 2 months after the last transfer of the $237,000 into the campaign, Mr. Oxendine bought 3 more units of debt from Kathmandu Collections LLP. If you add up the down payment on the home, the 2 investments in debt, as well as the shortfalls in the client funds, you get to 99.2% of total funds transferred from Oxendine Working for Georgia that passed through to personal assets somewhere else. They weren't used for legitimate business purposes. They were personal assets. Now, rounding out, as I promised, we're approaching the end of this. The source of final payments. This is important. The commission amended its complaint on September 18th, 2015. In fact, it was kind of known beforehand that we were going to be making these allegations, thanks to the AJC and a few others. Mr. Oxendine liquidated his Oppenheimer brokerage account. Remember the $200,000 that was transferred in from the sale of his home? That's the source of final payment. He did not begin closing out those accounts until such time as the September 18, 2015 amendment was filed to the case alleging that he had violated the Campaign Finance Act for unlawful transfer. Additionally, there was a cash payment. Mr. Oxendine was going to argue that he kept monies in reserve to be able to pay these loans to various third parties if they failed, which he claimed they did. But if you'll notice that there was a $38,000 and change cash deposit made into the PC firm so it could pay back Oxendine Working for Georgia. And then shortly thereafter, it was pulled right back out. All that to say was Mr. Oxendine had no intention of repaying the loan because he had made no repayments, he had made no interest payments until he was sued. At which point he scrambled for cash in order to pay back the loan so he could say that it was an investment for the return of interest. I understand what he's going to say, but I'm afraid that the facts just don't jive with what he actually did. Now, the final payment that closes all of this out, there were 2 checks, and this is important to note. The first check, the 1099 check, which yes you have, was listed as return on investment. And of course, that came after we sued him. The check never cleared the bank, although that is the check that was uttered to the commission as proof of final payment.
When you say the check didn't clear, was it under cash or was it not honored?
Not honored. And next slide, it was returned. So we had another one that was issued, and we never knew about it until we got the bank records. Another proof that he did not have the funds in reserve that were readily available to pay back the loan he made in his investment. He bounced the check as he rushed. And his brokerage account took some time to liquidate assets. Oops. Just to make sure. Yes. Okay. Sorry. When does the investment get paid back? I know you've seen it. The total amount of interest that was paid on a $237,000 loan for a 34-month period was $8,797.50. which would be a simple return of 3.71% over a 34-month period. I don't know about you commissioners, but I can't get rates that good. My current HELOC sits at 7%, and I pay a lot more interest than $8,000 on a much, much smaller balance than $237,000. As we've discussed, there's no loan agreement, there's no payment schedule. There was no payment of interest until he was sued. Only then did he have any intention of paying back the funds from his campaign. With that, Commissioners, allegations 1 and 2 are done.
All right, and so just to make sure I fully understand your argument, Mr. Lynn. Your argument is Mr. Oxendine utilized his law firm account in order to use the funds out of the campaign account personally.
Correct. If the commission may recall, since we stipulated the prior proceedings, the motions to quash before this commission and in front of Fulton County Superior Court relating to the IOTA, Mr. Oxendine fought tooth and nail to not have those funds disclosed. He wanted to be able to make the argument, as he'd done from the beginning, that it was an investment in his business. And he believed, wrongly, that IOTA and bank accounts are secret, that they cannot be revealed pursuant to subpoena. And without knowing the laws, it's not before the commission. Bank accounts are never secret. They can always be revealed. There's no privilege. They're always reachable by subpoena because they're considered business records that belong to the bank, not to the customer. Only once those accounts were revealed to us and we could show that the funds were never used as an investment in business, did we start getting these alternative theories of, well, I loan money to clients, I loan monies here, I bought debt, I purchased my home. It's a pure pass-through. It's a legal fiction.
And so at first, they made the statement it's an investment.
Correct. In the firm.
And then they made the statement it's a loan.
Correct.
Do you have to have a loan agreement under the Campaign Finance Act for it to qualify as a loan?
I would argue that the loan is not authorized by the Campaign Finance Act at all.
That's what I understood, that
Correct.
your argument is that loans aren't.
They're not authorized. A campaign is authorized to get a loan to fund itself. It is not authorized to make loans to others.
Can a campaign make a loan to another campaign, or does it have to gift to the campaign?
It has to gift under the current terms of the CFA.
And
You
what
are
is,
authorized to make contributions to other campaign committees and
so what is the authority that a campaign cannot make a loan?
it's absent from the Campaign Finance Act.
So it's silent one way or another?
It is silent.
Okay.
Now, we list in that ordinary and necessary expense, and it gives a very exhaustive, these are proper and ordinary expenses. It also discussed how you can do a campaign investment or campaign assets to get more money into your campaign. But it doesn't discuss a loan. It doesn't discuss how you can transfer your assets to other entities for the purpose temporarily of loaning it for return of interest. It's just simply not authorized. And it definitely doesn't pass the but-for test.
Talk about that if you will, Mr. Lane, because I'm curious as what is the staff's position on whether, let's assume it was a loan.
Sure.
And let's put aside for a second whether or not loans are even authorized. How would a loan meet the but-for test? Explain to me the staff position on the but-for test and the utility of a loan and whether or not it meets that but-for test.
Thank you for that question, Commissioner. The but-for test is important because at this point you have to remember Mr. Oxendine's campaign was closed. He had lost the election in 2010. These transfers occurred in 2013. Under the ordinary necessary expense and the but-for test, you're only allowed to make transactions with your campaign funds that further your campaign for office or that further your ability to execute your office. So for example, if you had to buy a campaign staff, or not buy, that's bad wording. If you have to pay a campaign staffer to work as your intern during legislative session, that's authorized. It's not for your campaign, but so you can execute your office. You can pass legislation better. You can be two places at once. That's authorized. What legitimate purpose, I would posit to the commission, did Mr. Oxendine have to loan funds for the return of interest in his campaign? The campaign was over. It had no outstanding debts. It had no outstanding obligations that it needed to pay. It had no need for additional rates of return on interest. In fact, it actually got a higher rate of return on the money market mutual fund it already had that it had its investments in. As you saw on one of the earlier slides, total interest being paid was about $30 per month on the bank balance. So the need for increased funds just wasn't there. So there was he wasn't furthering his campaign for office, and he wasn't.
I mean, he could make an argument that he was potentially going to run again, and he was increasing the interest to make more money. I get that, but so in the last question, they're going to take a break. They're going to hear from Mr. Chalmers. So first, is your position number one is if it was a loan, it violated the act because loans are not permissible.
Correct.
If it was an investment, it violated the act because it didn't properly report the investment.
And that it was not titled in the name of the campaign. It's
Okay.
personal assets that he purchased.
So your allegation is regardless of how they characterize it, it's a violation, whichever way. Okay. All right. Any further questions? So we're going to take a 10-minute, we'll say 5, we can do 5. 5-minute recess, and then we'll reconvene. All right, if we have everyone, I'll call the meeting back to order. And just for the record, the commission staff has presented their case for the first and second allegation, and Mr. Chalmers, who's on behalf of Mr. Oxendine, is going to present his opposition. Mr. Chalmers, whenever you're ready.
Thank you, Mr. Chairman. As we are all aware, this is a preliminary hearing. The sole purpose of a preliminary hearing is to determine whether there are reasonable grounds to believe there's been a violation of the act. Much of the factual material that you saw presented to you is irrelevant largely for this purpose because we're getting very much lost in the weeds and losing the forest. The question is what is legal and what is not. The factual presentation that we received from Mr. Lane we just got last night. So I'm not going to dive into those facts in great detail and try to refute them. We can save that for the APA hearing. I will make the following those statements. Some of the characterizations of the facts are completely inaccurate. For example, the assertion that Mr. Oxendine's law firm used campaign funds to repay obligations owed to clients, he strongly objects to that and denies that allegation. I think it's important to note that Mr. Lane presented alternate theories. He admitted on a number of occasions as he was making his presentation he doesn't know what these entities are or what the transactions were for. It's a lot of speculation. But the most important thing is that we do dispute any characterization that Mr. Oxendine used campaign funds to pay back clients. We do not dispute, without getting into the weeds on particular transactions, that the funds went to the law firm and from there were loaned to the law firm itself, to Mr. Oxendine personally, and to other third parties. Our position is that that is perfectly legal under the Act. At the end of the day, Mr. Oxendine personally guaranteed that the campaign would profit from those loans and repaid, the campaign was repaid back from the law firm as was properly disclosed on the disclosure reports. The full amount of the principal plus nearly $9,000 in interest. It's important to note this is a commercially reasonable transaction that benefited the campaign committee. The campaign committee made money off of this transaction, and it was a perfectly legitimate loan. I think that it's important to note, I think Mr. Lane has sort of hit it on the head what the Commission's position here is, the Commission staff's position, and why it's just wrong as a matter of law. The contention that a campaign may not make a loan as part of an investment just flatly misstates the law. Before we get into that, though, I want to remind the Commission one thing that's missing from Mr. Lane's presentation and the prior briefs and all of the filings is this act must be construed in Mr. Oxendine's favor in this matter. The Georgia Court of Appeals has held, and it's on your screen now, if I can get it up. State Ethics Commission versus Moore. The Campaign Finance Act is in derogation of the common law, and it must be strictly construed and in a manner as favorable to the person against whom a forfeiture or penalty would be exacted, as is consistent with fair principles of interpretation. What that means is that if there is a fair principle of interpretation of this act that benefits Mr. Oxendine, the Commission must adopt it. I would respectfully submit that the argument that Mr. Lane has submitted to you goes the exact opposite extreme and proposes a version of the act which most favors the commission rather than the candidates.
Mr. Chalmers, is this case in your materials or in any of in the filings, Mr. Secretary? Is it in the?
It is in the record of the case in previous filings, sir.
Okay, thank you.
Yes, sir. So let's talk a little bit about the law and what it does and does not allow, and whether it allows for a loan to a candidate in particular. The definition, and first up, just a couple of observations. We made some of our arguments in our initial response to the complaint. Mr. Lane in his presentation again reiterated that the commission staff believes that these transactions violated some provisions of the code which are purely definitional. So for example, 2153 16.1, that's just the definition of an investment. That definition doesn't form the basis of a violation. You can't violate that provision. We've made that point before. The Act says that an investment means the investment of money or capital to gain interest. It does not contain any limitations whatsoever on where those investments may go. And the Act itself says that and the Act and the rules say that such investments must be reported. The fact that the Act speaks of interest clearly means that loans are legal, because that is how you earn interest, by loaning money. In Mr. Lane's presentation, he basically says that he asked the question, can candidate loan money from their campaign to others? And he says the answer is not really. And in support of that, he really only cited to one provision in the law, which is the reporting provision, which he said that you must disclose profit or loss from the sale of an investment. And his reliance on that says the absence of interest from that suggests that the Act was not designed to permit loans. The Commission's own rules, 189-6-.08, reporting of investments, says that an investment made with campaign contributions and held outside the candidate's depository account, and I'm paraphrasing, shall be reporting, and the reporting must identify interest, dividends, profit or loss from the sale of such investment. The Commission's own rules contemplate that you would report the interest you earned on an investment. So I respectfully submit that his argument that you can only purchase stocks with campaign funds is just flat out wrong.
So a quick question. These transfers, do you characterize them as loans or investments?
I characterize them as both, because a loan is an investment. Under the Act, an investment is the investment of money or capital to gain interest. That is effectively the definition of a loan. Loan is not defined in the Act. Strictly construing that in our favor and just through basic application, anything that you invest to gain interest would be a loan. And
I'm sorry, go ahead.
yes, sir. So I think that
I think Commissioner Watts is.
I just want to, this is a question I asked earlier, or a twist on the question I asked earlier, but so Mr. Lane says loans are not allowed.
yes, sir.
And you agree with that?
The loans are not allowed?
Loans are prohibited under the Act.
No, I flatly disagree with that. Loans are permitted under the Act. They are investments.
Okay, so I guess my question will go back to Mr. Lane later, but I am curious as if loans are prohibited under the Act, because I had the same concerns that you are now raising, that the definitions that we were looking at look awfully similar. I want to know what loan, quote unquote loan, however we're going to define that, would be prohibited, and how that's different than an investment.
Our position, Commissioner, is that there are no loans that are prohibited. There is no guidance anywhere in the Campaign Finance Act that says where you may or may not loan money from the campaign. And our position is they are permitted investments pursuant to the definition of investment and pursuant to the very reporting provisions in the Act that Mr. Lane cited and the rule that he did not, that require the reporting of interest. For example, let's think about this hypothetically. Could a campaign committee purchase Coca-Cola stock? I don't think there's any question. The answer is yes. Well, what if it's a bond? Can a campaign committee go buy U.S. Treasury bonds? Can they buy Coca-Cola bonds? Those are all loans. Can they put it in a promissory note and gain interest on it that way? The money is being loaned to the bank. All of that is perfectly legal. There is absolutely nothing in this act which makes any of those transactions illegal. And I think, Commissioner, you highlighted a very important point in Mr. Lane's presentation. He attempted to interpret the Campaign Finance Act by referring to a definition of investment in Black's Law Dictionary because it doesn't mention interest, rather than the definition that's in the act itself, which does. I think that's very revealing about the nature of the argument being made here. Loans are clearly permissible, and that is our position. Now, let's take a look at the law.
If I may, let me offer you another hypothetical, and I'll ask you to tell me if you think this is legal. So, as I understand it under your definition, so if I were a candidate for statewide public office,
Yes, sir.
I could have a campaign committee, and I could take funds, accept contributions from the general public. And my brother-in-law might decide that he wants to get into the business of flipping houses. And so he could establish a real estate firm because he's going to flip houses.
Yes, sir.
And then I could loan him money. He gets into flipping houses. And as long as he pays me back or pays the campaign back money, or maybe he doesn't pay it back, it's an investment. Maybe the investment goes belly up and he doesn't make any money. But I could do that because my campaign is saying that I'm getting into the business of flipping houses. I'm going to make an investment in my brother-in-law's real estate company. He's going to flip houses. And maybe he pays us back with interest, maybe he doesn't. But as long as that loan is an investment, that's okay.
Yes, sir, absolutely correct. And in order to make it not correct, you have to cite some provision in the act which prohibits it. Mr. Lane was citing language on the but-for test and various different other things. We'll talk about that in more detail in a second. But that argument conflates two things. Number one, it conflates an investment with an expenditure, which are two totally different things. And it also overlooks the fact that federal law and state law on this issue are very, very different. Georgia has a statute which has a personal use provision. It's really not personal use, it doesn't say use. It is unique in the campaign finance world, and it is uniquely badly drafted. If this case proceeds at the end, we fully intend to raise a constitutional challenge to the vagueness of the statute. This agency does not have the authority to rule on constitutional issues, but we intend to raise that later in judicial review if this goes forward. What it says is that campaign contributions and the proceeds thereof may not constitute personal assets of the candidate. Well, the campaign finance staff's position on that is, if I'm understanding, that means campaign funds can never end up in a candidate's personal account. Is that basically? Okay. Let's think about that for a second. What happens when a campaign reimburses a candidate for mileage? Campaign contributions and the proceeds thereof have gone to the campaign's personal account. Why is that legal, as this commission has said for years? What happens if a candidate sells a computer to his campaign committee? What if he provides accounting services, products, services to his campaign committee, and they pay him for that? Campaign funds have gone into the personal account of the candidate. Under the legal theory that's being offered to you today, which is, again, the most extreme theory against the candidate, which is illegal given that it has to be construed most consistently in our favor, those transactions would all be illegal, but they have been permitted for years. So what's the principle at issue there? What makes those kinds of transactions legal? It is that we have got a commercially reasonable transaction in which the campaign is receiving value of equal or greater value than the money it expended. It got a computer back. It got some accounting services back. The candidate was traveling and what would have been a legitimate campaign expense, and they paid him for that. In this case, the campaign got nearly $9,000 of interest through these various loans. It got not only the principal back, it got money back, and it made a profit. And under the principle that applies equally well to the other transactions that I just mentioned, it should be entirely legal.
Mr. Chalmers, is there any documentation to support the campaign's position before this commission that this was a loan?
There were no doubt, there is not required to be, and the answer is no, sir.
Okay, so the example that you gave earlier about, and I wrote it down because I thought it was an interesting quote. You said you earn interest by loaning money, right?
Yes, sir.
And so banks certainly earn interest by loaning money, and they have loan agreements that say you're going to pay the money back
Yes, sir.
at a certain interest rate. We're going to charge you interest. Credit card companies, all financial institutions that I'm aware of loan money for the purpose of earning interest. And there are loan agreements that specifically spell out how that interest is going to be repaid
Yes, sir.
and the projected earnings. Is there any documentation to suggest that?
No, sir. There is not a direct answer to your question, but there's also not required to be. There is nothing in the Campaign Finance Act that requires that. In the past, the Campaign Finance Commission has permitted candidates to pay themselves interest on loans that they pay to the campaign without a promissory note. That goes back to Mr. Thompson's time as executive secretary. So there is no requirement. Now, would it have been better if there was? Sure. Does that affect the legal analysis of the validity of the loan? No, sir.
Well, and I get what you're saying. I get that there's no requirement that there be loan documentation. My understanding of what you're asking this commission to accept is the campaign's representation to this committee that it was a loan without any type of documentation. And I'm just getting from you that you want us to accept on good faith that it was a loan in the absence of any documentation that it was a loan.
The transaction qualifies as an investment because it was a loan under the Act.
Okay, but again, there's no investment protocols. I mean, as I understand it, Oxendine PC, unless you tell me something different, they're not a licensed securities broker, correct?
I don't know the answer to that question.
Okay, do you have any evidence that they are a licensed security broker?
No, sir, I did not come prepared to discuss that question.
Okay, so they don't trade in stocks or securities, they don't trade in real estate or mutual funds or anything of the sort?
I can't answer that question.
Understood. Well, I'm going to operate on the assumption that they don't in the absence of any evidence that they do. So if there's an investment or a loan in the absence of loan documents, loan agreements, securities document, prospectus, things of that nature, are you asking this commission to take on good faith in the absence of those documents that it was either a loan or an investment?
Well, I would say that those sorts of requirements have never been imposed for loans going the other way by this commission.
I understand this is not a requirement. I understand that having the documentation is not a requirement under the Act. What you're representing on behalf of your client is that it was, in fact, a loan, presumably with the intent to be repaid with interest. And I'm asking you, is there any documentation to support the representation that you're making before this commission on behalf of your client?
No, sir, I have not seen any documentation no, the answer is no. Going back to the law, and there are two provisions, and one of them I think is up now on your screen, that are alleged to be violated that are not definitions section. The first one is 21.5-33A. This provision, frankly, is not applicable here. It talks about how contributions shall be used for expenditures. The Act differentiates between investments and expenditures. Expenditures are when you spend money for campaign purposes, like you buy a car, or you buy TV ads, direct mail, that sort of thing. When you spend money for those purposes, it must be an ordinary necessary expenditure in furtherance of the campaign. That is different when you make an investment. So for example, the theory that the commission's staff is proceeding under, let's say again that we invest money in Coca-Cola. And let's just say for the ease of reference, it's some equity, we buy some stock. Their position is once that money went to Coca-Cola, anything that Coca-Cola did with it would necessarily have to be an ordinary and necessary expense for the campaign. That's the theory. That is not the way that works when you make an investment, when you make a loan. That provision applies when I make an expenditure out of the campaign to purchase something for the campaign. So 33A, we respectfully submit, does not apply here, just simply inapplicable to an investment. On 33C, the language, sorry, we're having to do two different screens, so it's going to take me a little bit to get Am I the right one? Yep. I can't see that one. I'm sorry, I'm going the wrong way. I apologize. Is that right? There we go, okay. So this is 33C. What does it actually say? Mr. Lane's characterization of it, and I don't blame him because it's pretty common in the campaign finance world, is to say it's a personal use provision. The word use does not appear anywhere in there. It is different from federal law, which we'll look at in a second. What it says is that contributions, basically campaign funds, shall not constitute personal assets of the candidate. And one of the questions that was posed during Mr. Lane's presentation, and I think Commissioner Barnum, it was by you, do campaign funds remain assets of the campaign when loaned? The answer is absolutely yes. They are still assets of the campaign, just like if you buy a treasury bond, you have an asset of the campaign. It's just being invested and earning interest. It still remains, it's not a U.S. Treasury asset. The U.S. Treasury, in fact, has a liability to repay that fund. So when monies leave the campaign for a purpose of an investment, that doesn't mean they constitute the personal assets. Let's also remember that if you've got any hesitation or doubt, any of us do, about what that means, let's go back to the requirement. It must be strictly construed in favor of candidates and defendants. This is a case of first impression, to my knowledge. I don't believe there's ever been a case where we've had a question pop up of whether campaign funds may be loaned directly to a candidate. Am I wrong?
You're not wrong.
No, so I think this is a case of first impression. There's no guidance. There's nothing saying it's wrong. And this act, which is the primary reason why it's contended to be improper, is unconstitutionally vague and it doesn't apply. There are, I'm trying to save you all some time because we've skipped ahead. I think that the basic principle that applies with this statute is it would be violated if someone were to take assets from the campaign and claim ownership of them without repayment. That's not what occurred here. And I don't believe that applies to a loan situation. And I think that the question of ownership is also critical because that's a major portion of the Commission's case. If you look at Mr. Lane's PowerPoint presentation, he said that the basic issue is who owns what. Well, Mr. Oxendine didn't claim ownership of loan funds. These funds were still owned by the campaign. They were campaign assets on loan, and I think that's a perfectly reasonable, legitimate interpretation of the Act that is consistent with statutory principles of statutory interpretation. And as a case of first impression, I respectfully submit that regardless of these, the nature of these exact transactions, this was an investment under the Act. It was returned with interest. It's permissible under the Act. There is no law in Georgia or prior precedent saying it's illegal. And for that reason, we respectfully submit that there are not reasonable grounds to believe that the Act has been violated, and we respectfully request that the case be dismissed.
So, Mr. Chalmers, if I may,
Sure.
what did the campaign do with the money? What did the law firm, do with the money that was loaned by the campaign?
Though I'm not prepared to get into those details at this point. We just saw Mr. Lane's presentation. The only documents I've seen on that is the BB&T records that were produced. Those records suggest that the money was loaned to Mr. Oxendine personally, that the money was loaned, in fact, some of it went to the campaign's operating account. Mr. Lane has, for example, characterized some of those expenditures as personal, citing, for example, the Atlanta Athletic Club. Without deviating too far off of your question, the Atlanta Athletic Club is a perfectly legitimate expense for an operating account of a law firm. Many law firms have accounts at clubs for marketing and business development purposes. That's not a personal expense. But the money was loaned to Mr. Oxendine personally, it was loaned to his law firm, and it was loaned to other third parties. And so, without going into specific transactions, that's basically what happened.
So here's what I'm struggling with. You just said a couple of minutes ago that the money that was loaned from the campaign still belonged to the campaign. And then just now you just said that the money that was loaned to the campaign was used for Mr. Oxendine personally. The money that was loaned from the campaign to the law firm
was used for Mr. Oxendine personally. You mentioned
It was loaned to him personally. Yeah.
loaned to him personally,
Right.
okay? And that the athletic club is a perfectly reasonable expenditure for a law firm.
Mhm.
Here's my question. If the money that was loaned from the campaign to the law firm, that was then used for some of those other expenditures, was there any agreement or understanding or permission from the campaign to the law firm that it could then use that money for those other purposes?
Nothing in writing, no, sir. And I think
Here's what
it's
I'm getting
important.
at. Here's what I'm getting at.
May I finish answering that just one?
Absolutely.
I don't mean to cut you off.
No,
I
I
finish that answer.
I apologize.
This is, and I think this is fairly common when you see people who are on both sides of a transaction or running the organizations on both sides of a transaction. Mr. Oxendine, the campaign was over. There's nobody else in the campaign committee at this point, and so he was the treasurer of the campaign committee. He's also the sole member of the law firm. So oftentimes I think you have transactions where people like that don't do loan agreements, even though because they are two separate legal entities, they don't do loan agreements because they know what they're doing. I don't think it's a legal requirement. I can tell you there are, to my understanding, no such loan agreements or documents in this case.
So I'm going to take issue with that piece of it because I think educated lawyers do, which I believe Mr. Oxendine is, understanding that as a lawyer, he should probably document this transaction, but I get it that it's not a requirement. The examples that you used when you talk about loaning money and still owning the money, all of the examples you use were when financial institutions or companies loan or invest or sell securities. They still own it. I can't buy Coca-Cola stock and then go sell that Coca-Cola stock on my own, because Coca-Cola has an interest in that stock. If I'm going to sell the Coca-Cola stock, I need to go to a licensed broker or securities dealer or sell it back to Coca-Cola, and then Coca-Cola will give me the money back. I can't then go sell Coca-Cola stock. That's the example that, you know, the idea of when you loan money or you invest money, you still own it. That means that the person to whom you've loaned the money can't then do something with that money without your permission because you still own it. What I'm trying to get at is how, I'm really trying to understand the campaign's argument that it owned money. It had a secured interest, if you will, in the money that it loaned or invested in the law firm, when the law firm then went and did something else with the money without the campaign's knowledge or without the campaign's approval. How does the campaign still own that interest?
I think that because they are still law firm, you're just differentiating between whether or not the recipient of loan funds has to obtain approval from the lender for everything that lendee does with the funds. That's never the case. I've never seen a circumstance where, hypothetically, that's a bad way to say that, I've never seen a hypothetical circumstance. I don't know of a case where somebody buys Coca-Cola stock and then attempts to direct how Coca-Cola spends that money and invests. Most people don't do that. I think that with all due respect, sir, you're also applying a standard which I understand and respect, but which has not been applied by the commission ever with respect to loans going the other way from candidates to campaign committees. In this case, early in his campaign, Mr. Oxendine loaned the campaign, I want to say $250,000. He was subsequently repaid that money. He could have charged interest, but he didn't. I don't believe that any of the kind of documentation you're talking about occurred then either, or that it would be required to be. But when those monies were loaned by Mr. Oxendine to the campaign reported them and the receipt of that, but those were still his assets.
I understand. And like you said, this is a case of first impression.
Yes, sir.
So if the campaign loaned money to Mr. Oxendine personally, well, when you talked about, you know, owning the money and not having to get approval, if I borrow money from the bank to build a house, I build whatever house I want to build. The money belongs to me. My obligation to the bank is to repay it with some form of interest. The money doesn't belong to the bank. The money belongs to me. My obligation is to repay it with interest. And I can say that I'm gonna go build a house, and maybe I don't build a house. Well, then perhaps I'm in breach of my loan agreement, but the money belongs to me. How is that different than this circumstance we're describing here?
I think that you're getting into the sort of deep accounting principles about what is an asset and a liability. And my response to that is that when you're attempting to determine how this Campaign Finance Act must be construed, is there another reasonable interpretation of personal assets that does not necessarily comport with any other requirement of the law, but is consistent with fair principles of interpretation? Regardless of how it's done in securities industry, regardless of the requirements that banks have because of the banking code or any other provisions that they make, in the world of campaign finance, when this law must be strictly construed in his favor, it is a personally reasonable construction of the act to say that funds loaned to a candidate are not the candidate's personal assets, because as Mr. Lane himself said in his presentation, the question turns on ownership. Is there a claim that these are owned? And I don't believe that is the case in a loan such as this. And like you said, sir, it is a case of first impression.
Okay, thank you.
Yes, sir.
So Mr. Lane said that if this was an investment, Mr. Oxendine's campaign account or committee would be required to make a reporting identifying what the investment is. Do you agree with that?
The investment, it does need to be reported. Yes, sir.
And did Mr. Oxendine report the investment?
He reported the investment on disclosure reports that were filed, amended disclosure reports filed in October of 2015.
And did he report it for all of the implicated campaign periods that he needed to?
In the amended reports, he reported all of the transactions that had happened previously.
Okay. Because I
Well,
think
the transactions between the report doesn't really permit any way to go beyond the initial transaction. The reports disclosed the money went to the law firm, came back from the law firm with interest. I'm not aware of any other circumstance where the commission has required that you go beyond that and try to disclose where all the various different monies have gone beyond that. And frankly, the investment provision reporting is relatively new. Not a lot of people do it. There's not a lot of guidance on it. But I believe it was done properly in the amended reports.
and Mr. Lane, we'll need, your input on that, but my thought is that there's a lot of uncertainty here about whether a loan can qualify as an investment, or whether a loan is even permissible. There is an agreement between both of you that at a minimum, it was an investment. There's also an agreement between the two of you that at a minimum, you have to report the investment. There seems to be disagreement on whether or not the investment was properly reported when it needed to be reported. And I think Commissioner Watts has a question. I will say, Mr. Chalmers, looking at the data here, it doesn't look good, in my opinion. I mean, if you've got money going from a campaign account to a law firm in which Mr. Oxendine is the sole equity owner, and money thereby going to pay earnest money or down payment on a house, which is deeded to Mr. Oxendine personally, that's not a good thing.
Well, the optics are different from the law. I mean,
No, I understand that.
what is that legal? And I think this is the natural reaction of many people in the campaign finance world. That's why we've got so much press attention on this today. Oh my goodness, campaign funds went for that purpose. Is it legal? And I think that before you all can make a determination about whether there are reasonable grounds to believe the act has been violated, which is necessarily a legal and a factual determination, you have to make the legal determination about whether it was a violation for there to be a loan. I think that guidance is also extremely important, because if we're going to go forward in an APA hearing, whenever that occurs, we're going to have a full trial on this. It's going to take a lot of the Commission and the Attorney General's office time and resources, and it would be a shame to go through that whole process, come back to the Commission afterwards, after a ruling has been done, or order has been issued, and then get the Commission's interpretation of what the law is, which we then take up on judicial review on an appeal to a superior court. I think there needs to be a determination legally.
No, I agree, but even so, can campaign money, which you're in agreement with, is still owned by the campaign, be used not to further the campaign, but for personal use?
That's not the question, sir. The personal use statute is a federal statute. Let's take a look at the federal statute. This is the, did I go the right way?
Well, let's hear from Commissioner White. So-
I want to hear the answer to this.
This is not a personal use question. Under federal law, campaign funds may not be used for personal use. That's where the but-for test comes in. If the campaign spends money for an expenditure that benefits the candidate that would have that would have existed otherwise, I hope I'm saying that right, a lot of double negatives, but the bottom line is if the obligation would not have existed but for his campaign, then you may make the expenditure. That's a personal use provision. The Georgia law doesn't say personal use. It says shall not constitute personal assets. Candidly, that is unconstitutionally vague. There's no guidance on what it means. And if it's strictly construed in favor of a candidate, then campaign funds should be able to be loaned to a candidate. Let's talk about it hypothetically, whether the commission would have the same concerns. If this had been documented in a promissory note, can a candidate issue money directly from his campaign committee to the candidate personally, document it in a promissory note, pay interest over a period of time? Is that legal? And our contention is that it is legal. There is nothing in the act that makes it illegal. And for that reason, if a transaction
But wouldn't that allow, I mean, if you think about that extended, all right? Jake Evans for governor. I run for governor, I raise $10 million. I
pretty good.
I then write a promissory note for my campaign to me personally. And I was like, I'm gonna pay 8% interest. I now am $10 million richer. I then just default on the loan and I say, oh, sorry, couldn't make the payments.
Bad investment.
Bad investment.
Yep.
And then I'm able to use the money to buy a house or whatever else so extrapolating that, it eviscerates the campaign finance rules. I mean, you don't have to report what the money is being used for if you're making the investment. Go ahead.
That's a wonderful argument for the General Assembly. That's a policy argument of what the act should say. It's not what it says. And this commission's job is to enforce the law as it is written, even though it is oftentimes written incredibly poorly. With respect to the optics, though, of losing all the money, the campaign, that happens anytime anybody makes an investment. If I buy Coca-Cola stock, $100,000 of Coca-Cola stock with my campaign funds, and there's a recession, or if I buy airline stock and there's a plane crash or a terrorist attack and I lose 50% of the value of the stock, I've lost money. Does that mean it was an invalid investment? No, not at all. It just means it was a poor investment. If you get the benefit of the positive side as well, that's why people invest funds. One other thing to note about this is that the campaign committee, where the money was sitting in those campaigning, it was earning virtually no money at all. By virtue of this transaction, the campaign profited more than it would have if it just let the money sit in a money market account.
Mr. Chalmers?
Yes, sir.
Actually, it's a question for you and Mr. Lane. Chairman Evans, I believe, asked a question or suggested in his question that there was agreement between the two of you as to whether or not the money loaned from the campaign to the law firm was still owned by the campaign. Maybe I misunderstood the chairman's question. I didn't think that there was agreement, but if there is agreement between the two of you, can you clarify that for me?
Our contention, and I do think there is disagreement, I think you sort of stated, if I heard you correctly, my position, our position, which is that the campaign assets remained assets of the campaign even when loaned, and therefore they were not the personal assets of the candidate. And I think I'll let Mr. Lane speak for himself.
Mr. Lane?
Commissioner Martin, you're correct. Our contention is that these were not loans, that they were pure conversion of funds to personal assets.
And that, well, and I want to focus in specifically on the staff's argument that once those funds were in the account or in their possession, using that term in general sense, not in the legal sense, of the law firm, that they were owned by the law firm.
That is
Is that
correct.
the staff's position?
That is the staff's position.
Okay.
But can you convert something that you pay back?
And we're getting a little off field on this one because to date, Mr. Oxendine has never provided testimony under oath that this was a loan with an intention to repay. It's just from his counsel's statement in his place, which carries, with respect to my brother lawyer, absolutely no weight. This is Mr. Oxendine saying, trust me, I promise it's a loan. Although the circumstantial evidence that has been presented before you today, which his counsel's had just as long as I have, shows that the theory changes depending on how adverse rulings go against Mr. Oxendine. It started off as a loan, well, it was never reported to begin with. He then gets sued. He then reports, oh no, it's a loan to my law firm. And then when we actually get the records to show that the law firm didn't use the funds at all, they were used for personal expenses and personal purchases, then it became, oh no, it's a loan from my campaign to my law firm, then to me, and then to other third parties. And the third party revelation came earlier this week because it's actually three theories that Mr. Oxendine has floated. The first two you've heard, this Monday, I believe, is the first time we've heard that, no, I wasn't covering for client shortfalls. Those were loans to third parties, including clients.
So if we, assuming that it was an investment, did Mr. Oxendine properly report the investment, Mr. Lane?
We would submit no, Mr. Chairman.
And why?
Because when you look at the reporting statute for an investment, which is in 21534, that B1F, you are required to disclose the profit and loss of your investment. I would also assert to the Commission that an investment is an expenditure. And that's one reason we include 21533A. 21533C, as you'll remember, is the statement where it says that the asset shall never constitute personal assets. 21533A is the disposition rule on what you can do with leftover campaign funds. And what the disposition rule says is that you can only use leftover campaign funds for ordinary and necessary expenses. It doesn't allow you to run off into left field and say, I'm going to start being a bank with my, leftover campaign funds. So that, and Mr. Chalmers is correct that you have to strictly construe the Campaign Finance Act. That does not mean that you create out of whole cloth brand new reasons for which campaign funds can be used. Nowhere in 21533A, nowhere in 21533C does it say you may loan funds or act as a bank in order to generate funds. Because these are leftover funds from a campaign that is closed, and I believe I heard Mr. Chalmers state the campaign was over. Mr. Chalmers, or not Mr. Chalmers, excuse me, Mr. Oxendine was not raising further funds for another gubernatorial run. During this entire 10-year period, he has not taken one contribution from any other donor. These are all simply leftover funds.
Didn't you say earlier, though, if he wanted to invest in a Coca-Cola stock in order to increase dividends or interest for a future campaign, he could do that?
Correct.
So how do you reconcile that?
My argument would be it would depend on when he actually did it. I would not apply it to the facts of this case. For example, if I'm running for governor and fortunately I get $10 million too, I can only invest that money prior to the election before it closes out because different rules govern what you can do during a campaign and then what you do with your money once the campaign closes. And that's the disposition rule, which is why we included 21533A.
Let's try it. Try it out. Go ahead.
Did you have a quick? Okay. So to follow up on Chairman Evans' part about reporting it, this is Mr. Chalmers. If there was nothing wrong with it, why wasn't it reported until such time that the state amended their complaint to bring it to everyone's attention?
I can't speak as to why it was not reported initially. I think the characterization, though, that the amendments were done in response to the complaint is entirely wrong. You have to remember what the amended complaint said. The amended complaint was taking the position that Mr. Oxendine could not spend monies, not investments, wasn't talking about that at all, could not spend monies that he had raised for the primary runoff of the general elections at all. And that was the position that was in the AJC story that came out earlier, and I think the one that on which you opined, that was the basis of the amended complaint. It had nothing to do with investments. Or the allegations that we're discussing in the 2017 case. The disclosure reports were amended in October 30th of 2015, which was about a month later. But again, those was not in response to the allegations in those complaints because it didn't relate to that. I can't speak as to why the disclosure reports weren't initially right. I didn't represent Mr. Oxendine at the time.
Mr. Chalmers, the funds that went into the IOLTA account,
Yes, sir.
I believe in Mr. Lane's presentation, there was a shortfall on those IOLTA accounts, is that right?
We dispute that, sir.
Okay, what evidence can you talk to?
Oh, I'm not prepared. We just got that out. I mean, Mr. Lane presented that with us first time in the last couple of days when we met. We just got the documentation on it last night about 6 o'clock. I candidly haven't even had time to look at it, but we deny that the monies that came in from the campaign were used to cover client repayments or amounts owed to clients.
Do you deny that the funds went into the law firm's IOLTA account?
No, sir.
Okay. So if the funds went into the IOLTA account, I have two questions. If there were in fact shortfalls in the IOLTA account, whose obligations are those shortfalls?
I don't think that that's a matter of campaign finance law. I'm not prepared to address it.
Understood. I guess here's what I'm trying to get at. If the money that goes in, if in fact money went into the IOLTA account, and I don't believe you dispute that, and there are shortfalls in those IOLTA accounts, do you disagree that those shortfalls would be the responsibility of the law firm?
I'm not prepared to answer that hypothetical.
Okay. Then perhaps you can answer this one. Assume for purposes of this hypothetical that those shortfalls are the responsibility of the law firm. If the campaign still owns those funds, how would the shortfall not also be the responsibility of the campaign? Because
I think,
money.
addressing it in purely hypothetical questions
Sure.
without conceding there was a shortfall.
Understood.
I think you're asking about two stages of a transaction. One is a entity, the lender, loans money to the lendee. It's very rare that I've seen in circumstances where the lender retains control over how those funds are used or what they are, except for, maybe in
Except here?
securities and, sorry?
I'm sorry, except in this circumstance, because earlier you were just saying that the campaign still owns the funds.
Campaign does still own the funds. When I loan money to the U.S. Treasury, I still own the assets that have been loaned to the U.S. Treasury.
Okay.
I don't tell the U.S. Treasury where to spend the money, how that goes.
Right.
If the U.S. Treasury does that to cover an obligation for Brazil, the fact that they've done that, and they've done that without my knowledge or approval, does not mean that the funds that which they did that with were not still my assets
Okay.
that they owe to repay to me.
Okay, I understand your argument. Thank you.
Yes, sir.
All right, Commissioner Watts.
With respect to reporting violations, because I know there's been a lot of discussion about that, are those at issue for number 1 and 2, the allegations 1 and 2, Mr. Lane? Just purely reporting violations?
No, sir.
Okay. Now, for Mr. Chalmers, is personal asset, the term personal asset or asset, found anywhere else in the Georgia Code?
And not in the election code?
Anywhere else in the Georgia Code was my question.
I can't tell you off the top of my head. I believe that we looked at that, and I cannot remember honestly. I don't know the answer off the top of my head.
So I want to go back to a question or an issue that you had raised. And you said the campaign still owns the asset when it traveled from the law firm to a third party to whomever it traveled. But there's no loan agreement or any sort of agreement or documentation of that. And then you said it wasn't a personal asset when it got to the law firm. It wasn't a personal asset of the law firm when it got to the law firm. It wasn't a personal asset of Mr. Oxendine when it
I don't think you could ever say it was a personal asset of the law firm. The law firm's a PC.
Okay, certainly, it wasn't a personal asset of Mr. Oxendine when it was used for whatever purposes it was used for that we discussed. How do we know, if there's no documentation, how do we know that it wasn't a personal asset? I mean, you're asking us to just, at face value, accept that it was still the asset of the campaign, not a personal asset. There's
I think
nothing
that's a
on either
legal,
side of
I
it.
think it's a legal question rather than a factual question.
Well, that's why I asked, where else was asset defined in the code?
I don't know that the phrase personal assets is defined anywhere else in the code.
So is there an admission?
It is
that-
definitely not defined
that
and it
there were-
can't be
that-
defined today.
I want to go back to the reporting thing. So are we in agreement? I mean, if we're looking at 21.5.16.1, says any investment made, and it sounds like we're in it. Mr. Lane argues it's not an investment, but you say it is an investment, right?
Yes, sir.
Okay. Any investment made with funds of a campaign committee held outside such committee's official depository account, and can we agree that it's held outside the official depository account? Do you agree with that? Okay. During each reporting period for which an investment exists or a transaction applying to an identifiable investment is made, when was this investment first reported?
The investment was first reported on the amended disclosure reports that were filed on October 30th of 2015.
And Mr. Lane, do you agree with that?
That is correct.
When was the investment first reported?
That's what we just answered, sir.
Do you know when it first occurred?
First occurred.
January of 2013.
So are we in agreement that it was not properly reported in violation of the code?
It was not reported on the initial disclosure reports that were filed for the 2013 timeframe.
So we're in agreement that the Transparency Act was violated because it wasn't properly reported.
I'm not going to make any concession on that. And among other things, Commissioner, that's not before the Commission right now. There is no allegation on that. We're here to talk about whether or not 33A and 33C were violated. Those are not reporting provisions. Those are, the issue is, can in fact loans be made to a candidate, to an entity owned by the candidate, or to other third parties? Commission staff's position is that no, none of them can be. None of those things can be done. Our position is that they can be done. And in light of that legal argument, we respectfully submit there's not reasonable grounds to believe there's a violation.
Since reporting under your scenario there is not an issue here, then it seems to me that we've sort of got a two-step question ultimately to determine here. One, before we ever get to your legal argument, we've got to buy the fact that this was a loan. And the only evidence that you've presented that it was a loan essentially is that there was an interest payment that was made after the lawsuit was filed. You agree?
I agree.
Mr. Lane, do you want to respond to Mr. Chalmers' opposition?
Very, very briefly. Commissioners, Mr. Chalmers is correct that we are at a preliminary hearing, and the standard before you today is probable cause, which the commission is required to determine as are there reasonable bases to believe or reasonable grounds to believe a violation of the Campaign Finance Act in the code. I would submit that based on the documentary evidence that both parties had made, and that was presented by the commission, you have enough evidence to cross that threshold. You're not having to find by preponderance of an evidence or even a reasonable doubt that a violation occurred. There is enough evidence to show that there is a dispute between the parties and that this case should proceed forward to a full administrative hearing before the Office of State Administrative Hearings. Additionally, I'm glad Commissioner Evans kind of brought up the parade of horribles. I'm always kind of loath to do it, but he gave the example of if I take out $10 million and I give myself a $10 million loan and I default on it, you basically abrogate the entire Campaign Finance Act, and he's absolutely right on that. There are additional parades of horribles that can be done. And the Campaign Finance Act does somewhat anticipate those when it deals with loans, and particularly loans to the campaign. And that is actually controlled in the disposition of funds, which is 21,541. It's the maximum contribution limits. And it would be subsections G through I. In that maximum contribution limit, it says that a contribution limit does not apply to loans that the candidate and the candidate's family makes to him or her. There's no contribution limit, and you can repay that subject to a $250,000 cap. We won't get into it, it's not applicable here. However, for maximum contribution limits not to apply to a third party, it must be a bona fide loan from a bank or other lending institution, and I interpret bona fide to mean you have loan documents, a repayment schedule, agreed upon interest terms, repayments. So that is the only way you can accept a $250,000 loan, not from your spouse, not from your adult children, and not violate contribution limits. So for example, if Mr. Evans wanted to loan my campaign money, he wouldn't be able to do it. He's not a bank, he's not a financial institution. He couldn't just transfer to me $30,000 as a loan because he would be violating maximum contribution limits, and so would I by taking it. So that's one of the grave horribles that the campaign is trying to stop with loans. And I know Mr. Chalmers said that we don't require loan documentation when it's going the other way to the campaign. That's actually just inaccurate. Because by the terms of 21,541, it has to be a bona fide loan. And if you tell me, you know, BB&T gave me a $300,000 loan, we're allowed to ask, well, give me proof that's a bona fide loan, or we're going to hit you with an exceeding maximum contribution.
One question, can you violate a definition section?
No, and it's a little bit of a cross between civil and criminal law, so you will forgive me. When you draft a criminal accusation, you always include the code sections that you're alleging because it's a fail-safe. So if you get the definition wrong in the accusation because you haven't included the definition code section within the accusation, it's surprise murder.
So I'm having trouble. The drafting of this is unclear. In terms of what I'm having trouble with is not necessarily the investment versus the loan, but it's the personal asset. So the evidence that you've put forth is his use of the money. And Mr. Chalmers, it's still on the screen, is contesting that personal use doesn't mean personal asset. And nobody's really framed it quite clearly on what is or is not a personal asset. I'm left to decide that on my own, I guess. If this is all a matter of first impression. But I find it hard to believe that, and I don't have the whole code in front of me, but I find it hard to believe that asset isn't somewhere defined to give us some assistance of what the legislature intended by those two words.
And I completely understand and agree. I think what the legislature was intending is that the term asset is a common definition. It's not some term of art. It is not a legally created definition. And that's one reason I included the Black's Law definition of both asset and personal asset. A personal asset is the asset in the form of money or chattels. In this case, Mr. Oxendine took campaign funds and bought a house. He bought a house in his name. Now, if it was titled in Oxendine Working for Georgia, and he bought the house that way, then he would have a legitimate argument to say his campaign made an investment in the home. Because then the campaign would own the asset. The campaign would own any profit or loss resulting from the sale of that home. In fact, Mr. Chalmers used that as his example. He misconstrued the staff's position on where campaign funds can go. Our argument is that when you are having campaign funds and they're just sitting in an account, just sitting there, not being used, they have to be in an account registered in the name of the committee. That's what's required by the law. You have to have a campaign depository account. Now, what he said is, well, you would never be able to transfer monies to a candidate for the mileage, is one of the examples he used. That's a lawful expenditure that's authorized by the Act, and you can transfer monies from your campaign deposit account into your personal account because you are paying that a lawful expenditure. Or even if Mr. Oxendine had loaned money to his campaign, and the example of the $250,000 in 2008 to get off the ground. We didn't allege that's a violation because he lawfully could expend the money from his campaign depository account to pay himself back. That's perfectly legitimate. So what we're arguing in this is that we're saying that besides Mr. Oxendine saying, I promise the assets really still belong to the law firm, they didn't. It's complete fiction, and it's part of his shifting theory on what the money was used for and where it went.
You mean to the campaign?
Correct, sorry. So, for example, and the biggest example is just the house, where now the admission that the Kathmandu Collections Triple LP, those were purchased by Mr. Oxendine in his personal capacity, and whatever monies he received from that investment didn't go back to the campaign. They
I
went to
made no
him.
concession on Kathmandu that he purchased in his personal capacity, just to be clear.
Well, the evidence we have for 3+ years worth of campaign accounts and Oxendine professional corporation accounts, no monies from Kathmandu ever made it back into either of those accounts. So if payments were made, they went somewhere besides who Mr. Oxendine is claiming owned the assets. So, and as we've discussed, and as you pointed out, loan agreements, repayment schedules, none of this ever became a loan until he was called out on it. And I understand what Mr. Evans was asking about, was reporting charged? And the answer is no, we couldn't charge it because what we had were self-disclosed reports that just simply had money disappear into thin air. So we couldn't allege failure to report a loan because we didn't know whatever happened to it. It went from $700,000+ to $500. So,
Mr. Lane, I would be remiss if I didn't ask you to address. So, the Act, if I understand your presentation, the Act does deal with loans to a campaign.
yes, sir, it does.
Can you offer any thoughts on the legislative history? If the legislature included a provision that talks about loans from to a campaign, they could have just as easily included a provision that talked about loans from a campaign.
Yes, sir, and you're making an argument more eloquently than I am. That because the legislature has been very specific on what authorized expenditures are, and it has been very specific on what loan requirements are for monies going to a campaign. They obviously showed that they knew how to limit those transactions. And by them refusing to authorize and put in language allowing the reverse loan from campaign to others, its omission is, to me, an example on grounds that it's not authorized.
So is your argument, and I'm not sure I'm buying it, this part, is your argument that the legislature's omission of language discussing loans from a campaign by definition prohibit loans from a campaign?
Not necessarily just the omission, it's also you have to construe it with the ordinary and necessary expense provisions that are controlled in 33A. Campaigns are limited in what they can use funds on, and it has to be an ordinary and necessary expense, and that's where the personal use in the federal comes out. Because when you read the personal use, which I think may still be up on your screen, personal use means any use of funds in a campaign account of a present or former candidate to fill a commitment obligation on down the list that would exist irrespective of the campaign's duties as a federal office holder. That was the example I gave to you. If you can't buy every meal on your groceries because you're going to eat whether you're an elected official or not. That's the same test this commission uses to interpret our ordinary and necessary expenses under 21.533A, which is the disposition of campaign funds, which is what we're dealing with in a closed account and how they must be disposed of.
But
Yes, sir.
according to Mr. Chalmers, I think his position, and if I'm mistaken, please stand up and tell me, his position would be, we didn't have any ordinary or necessary expenses because an investment's just allowed. We invested, or sorry, not you, the campaign invested, and interest was received. It was repaid back to the campaign account, and now under 533A, any proceeds from investing such contributions shall be utilized only to defray ordinary and necessary expenses and so forth and so on. So at that point, once the proceeds have come back, now it would be a violation if it wasn't used for ordinary necessary expenses. Unless, of course, the campaign intends to make another investment, because that's allowed under the code. Any investment is allowed under the code. Did I mistake that?
No, sir, I think you said it exactly right. 33A applies to expenditures of campaign funds, not to investments of campaign funds. I think you said it exactly correctly.
But again, what I'm having struggle with is that this personal asset piece. I mean, there's just, go ahead.
It's one of the things that unfortunately is true in the Campaign Finance Act in Georgia is that there is an awful lot of ambiguity in it. I think the staff, and we've dealt with these sorts of issues for 10 years or more. Back when Mr. Thompson was executive secretary, we dealt with all those sorts of things. And there's a lot of lamenting about the fact that the act is not clear. When the act is not clear, you have one option. You can interpret it in any reasonable way that most favors the candidate as a mandate from the Court of Appeals, because this is a quasi-criminal statute. And therefore, if you can come up with a definition, or we can come up with a definition of personal assets, given that it's not defined for purposes of the Campaign Finance Act, and we're not talking about assets, we're talking about the phrase personal assets, that comports with reasonable interpretations of this statute, and that benefits the candidate, you have to apply that. And we've given you exactly that. Personal assets means something that you permanently claim ownership of and take as your own. It does not include the circumstance where funds are loaned to a candidate or any other third party and repaid with interest. And I think that's a reasonable definition of what personal assets mean. I frankly think that the statute is so vague that it's subject to a vagueness challenge, and if it goes forward, we'll have to do that.
So I understand that's your position, and that's how you're going to proceed if this goes forward. But under the definition of personal asset that you just provided, how do we know one has claimed it as their own?
I don't know how the commission would go about proving that in circumstances. I mean, the commission would have the burden of proof, but I think that in circumstances...
Let's be fair. That's your definition. So how do we know with no documentation?
It's actually Mr. Lane's definition. He was talking about ownership in his presentation. I am agreeing that that is a definition that makes sense, that where campaign funds transfer over to a personal account, the candidate or anybody else repays those funds back with interest. They are not being claimed as owned by the candidate. I think the fact that they are returned with interest and a profit is made for the campaign establishes for you that there's no claim of ownership.
But here, someone called foul, and then it was repaid.
That's actually not true, sir, because you have to remember that, as we talked about before, Mr. Lane's sequence of events is that a complaint was filed in September of 2015 that raised this issue, and then the funds were repaid and reported. It was not that way because the complaint that was filed in 2015, which was an amendment to the Anderson case, reported amendment to the Anderson case, added an allegation that said that for previous years, Mr. Oxendine spent monies that he had accepted for the primary runoff and the general election, notwithstanding the fact that he had lost the primary. It was an entirely different issue. There was nothing about the law firm, there was nothing about loans to investors in that complaint.
When did you first start representing Mr. Oxendine?
At about that time.
What time?
The September, I think it was, of 2015, somewhere in there.
But I don't think, Mr. Chalmers, I don't think that your answer necessarily addresses the premise of Commissioner Rott's question, which I understood it to be, it wasn't until, whether it's the Anderson complaint or an amended complaint, it wasn't until a complaint about the money that went to the law firm was brought to the campaign and Mr. Oxendine's attention, was the money repaid.
No, sir.
That's not, okay, so.
No, sir. The complaint that was filed about the law firm money was filed 2 years later in 2017.
Okay.
This case has a 2017 style. The case that was initiated in 2009 When the staff amended it in September of 2015, no allegations were made on this issue. We were dealing with the other two allegations, the Anderson allegation about excessive contributions,
Sure.
and the allegation that they've added about you're not allowed to spend money for the primary and the runoff, which is a different issue.
All right.
But the complaint on this particular allegation was not filed until 2 years after the amended disclosure report.
Understood, but I don't think you disagree that the repayment of monies came after complaints about the campaign.
Well, complaints about the campaign have been pending since 2009, so necessarily that's true.
Okay.
So going back, and I don't necessarily like being taken down this rabbit hole in court myself, but I'm going to do it to you. So I understand the repayment, in your view, shows that Mr. Oxendine did not claim ownership of the asset, the campaign contribution. But here again, I'm assuming you don't think he ever claimed ownership of it, just by virtue of it being repaid, right? Even as he was using it, there was no ownership claim.
I'm not aware of him ever claiming ownership of the funds. I am not aware of any evidence or records that show that he claimed ownership of the funds. The records that I have seen are the records that were produced by BB&T. But I'm not aware of him claiming ownership of the funds or there being any evidence suggesting that.
So there again, I mean, what do we need, right? Because if it could be an agreement or a statement, an agreement. Does the candidate ultimately pass away and the estate never pays it back? Is that the date of ownership? I mean, I just don't know. Well, I mean, I have my personal view on this, but I'm asking what do you think that we need to know that someone has claimed ownership over an asset?
Well, whatever it is, I don't think you've got it in front of you at the moment.
I understand that, but I mean, is there
The
any?
investigation's been going on. I mean, subpoenas have been issued, and subpoenas that were issued were granted by the Superior Court. And we're here at a reasonable grounds hearing with the state having the burden of proof of establishing that there is sufficient evidence to move forward with an alleged violation of the act. It's not my burden to present evidence, and I would submit to you on the evidence presented here, there is nothing that shows Mr. Oxendine's claim of ownership of those funds. To the contrary, the record shows that the funds were returned with interest. I don't believe it's disputed that the funds came back. I don't believe it's disputed that there were nearly $9,000 paid in interest. I don't believe it's disputed that the campaign profited from the transaction. I think the only thing that really that Mr. Lane is able to point to is the timing.
But Mr. Chalmers, I mean, admittedly, it's circumstantial. I asked you earlier whether you knew what happened with his money, and you said that you weren't prepared to have a discussion today about what happened to the money. Mr. Lane presented at least circumstantial evidence to suggest that the money went to buy a $960,000 house. If, given that that's the only evidence that we have of what possibly happened with the money, I'm struggling with how that's not ownership.
He also presented evidence that was in his case in chief, where the money came back to the the campaign loaned $97,000. $96,500 of that was used as a loan for the down payment on the house. Mr. Lane noted that the records that were produced by BB&T then showed that nearly $300,000, about $290 and change, came back from the sale of another house back to the IOLTA account, $200 of which was subsequently used to repay the loan to the campaign. So there's evidence there going the other way as well.
Okay. My thought for a loan is when you have a loan, in order for there to be consideration, the bank transfers money to whoever the loanee is. And in exchange for that, they get a note of some sort. And the note qualifies as the exchange of consideration for the money. I think there's an argument to be made that at the point at which, and I think legally it may be true, at the point at which the money was allegedly loaned, the ownership transferred to Oxendine PC. At that point, there was allegedly another loan to John Oxendine personally, in which he received a warranty deed for a house. And, you know, I think both of you guys have done a great job. But I'm going to let Mr. Cranfield go ahead before
I have a really simple question. At this stage of the proceedings, this preliminary hearing, is there any burden that would fall back on you to prove that this was a loan?
No, sir. It's quasi-criminal act. We never have the burden of proof on anything, I don't think.
How would the commission staff have the ability to prove that negative?
I don't know.
Because you said that there's absolutely, the only thing that you've identified, again, for me earlier as proof of the loan was the fact that there was an interest payment made when it was. That's all there is, right?
Given the absence, at least to my knowledge, of any other written records on it, and the absence of any written records in this record before you now, that's all I've got to point to.
And Mr. Chalmers, do you have any legal authority to support an argument that this commission cannot consider circumstantial evidence to glean Mr. Oxendine's or the campaign's intent?
No, sir, I do not.
Commissioner Wong?
Yeah, so let me just get down to the vagueness issue one more time. So your position is that investments are contemplated by the Act, they're allowed by the Act. They don't have to be used for ordinary necessary expenses, right?
Yes, sir, they're two different things.
Okay.
The returns and proceeds of investments after they come back.
I got that, yeah, I mentioned that earlier. So then in 21.533A, just contributions to a candidate, and contributions here would be whatever funds he had in his campaign account. He got it from somewhere, that's a contribution, right?
Yes, sir.
And then ... shall be utilized only to defray ordinary necessary expenses. So putting aside the proceeds from investment, which, like I said, that would be the 8,000 or 9,000 or so that's coming back in, okay, from what your position is as a loan or investment. And then ordinary and necessary expenses is defined in 21.5.3.18, and that includes, in my mind, and I understand it says shall include but shall not be limited to,
Right.
a number of things that weren't necessarily what has been alleged that the contributions were used for in this case.
With the question I think that you're posing is an investment an ordinary necessary expenditure for the initial contribution, setting aside the proceeds?
Yeah, that's kind of where I'm going.
Right. Well, if the Act itself specifically defines the term investments, and it says you are required to report any investments you make with campaign funds, under any reasonable interpretation, especially one strictly construed in our favor, investments are permitted under the Act. And so, to the extent it's necessary to construe these provisions together, an ordinary and necessary expense would include investing campaign funds for the return of interest, or I forget the other language, I'm sorry. But I think that there really are different things. I think that the 33A is really talking about when you spend money, it's different from when you invest money. For example, and the one I keep coming back to, if you buy a Coca-Cola bond, what Coca-Cola does with that money doesn't have to be an ordinary and necessary campaign expense. What you do with that money when you give it to Coca-Cola has to be either an ordinary and necessary expense or an investment. An investment includes a loan. When the money comes back from Coca-Cola, then you take the principal and the interest that you got, and those need to be spent on ordinary and necessary expenses, and that's when you go back and 33A applies.
Well, I'm going to make a motion, and I think both of you guys did an excellent job. I think it's important to be mindful we're not the final arbiter. We are a reasonable grounds to believe the act was violated arbiter. And this will, if the motion prevails, will go before another arbiter who will make a final determination. To me, it's odd that if this was really viewed as an investment, it wasn't initially reported whenever the transfer took place, which I think was January 2013. I think there's some ambiguity on whether loans can even occur, but even assuming a loan can be an investment, it can't be a personal asset. And I think the point at which the money was transferred to Oxendine PC and then to him personally to get a warranty deed is going to qualify at the least as a violation of OCGA 2153C. And I welcome the Commissioner's input on whether 2153A was also violated.
I think you said 3C.
33C, that's correct. And Mr. Lane, if we're going to make a motion, do we need to specifically articulate the provisions that were violated?
I think that would be the safest course. I think you should reference the allegations as presented to you. That's simply just how we're going to be, we'll draft the order, of course, to effectuate what your motion is. And if I may, I would suggest that you, that's why we broke down, like allegation 1 has 1A, 1B, 1C, and then you have allegation 2A. I would reference the specific allegations you're finding reasonable grounds for, and then the code section you believe would be violated by that transaction.
Mr. Chairman, I agree, and on behalf of Mr. Oxendine, I would request to make later proceedings easier that you in fact cite the citation upon which you are proceeding, whether it's 33A or 33C.
Okay, thank you, Mr. Sherman. So I'm going to make a motion, and I'm going to start the motion for just 33C. Then we can have discussion, and if the commission decides to either amend and add 33A or not pass the motion, that's fine, but I'm going to move, and Mr. Lane, do we need to state a factual basis or just an overall motion?
I believe you can do an overall motion. I do not believe you have to have a finding of fact. Especially if you're showing if you're doing the allegation basis, like allegation 1A, it already has a factual basis that there was a transfer from here.
Mr. Chairman, the 1A, 1B, and those sorts of things, those, if I'm not mistaken, are the 4 transactions in
Yes.
which money went from the campaign to the law firm's IOLTA account. I'm not sure it's appropriate to have those as separate allegations. I think in as much as at this point, you're finding reasonable grounds, it's sort of one violation. It's the transfer of campaign funds. It's the same exact legal issue if that was the violation.
Okay.
And the main reason we separate them out, Mr. Chairman, is so they would be severable. So for example, if Mr. Oxendine were to concede the purchase of the home, but then argue that the second transaction was something else, it would be able to survive independently.
Well, I'll just make an overall motion that reasonable grounds exist, or strike that. I'll make a motion that reasonable grounds exist that OCGA 21533C has been violated.
Seconded.
So we got a second. So now we will open it for discussion, and we can discuss the merits of the motion, whether to amend the motion for 33A, and any other discussion the commissioners have.
And just as clarification, is this just for the violations that are in allegation 1 for calendar year 2013, or are we doing this together?
I understood it to be allegation 1, which is in 3 subparts, the 97,000, the 50,000, and the 40,000 that all occurred in 2013. And I'm looking at the presentation isn't numbered, but under allegations still in dispute, at least for my purposes, I'd like to offer an amendment to the motion that the commission vote in favor of a finding of reasonable cause to believe that OCGA 21-5-33A as well as 21-5-33C were violated by the respondent in 2013, based on the 2013 transactions involving the $97,000 transfer, the $50,000 transfer, and the $40,000 transfer from Oxendine working for Georgia to Oxendine PC's IOTA accounts.
Okay. So we've got an amendment adding 33A. Do I hear a second from anyone?
Second.
All right, we got a second. Any discussion on the merits of adding 33A? Is that you, Christian?
It is, yeah.
You got it. Sorry about that.
That's okay.
Thank you, Mr. Chair. Just on the formatting of the reasonable grounds and moving forward, I think just for the commission's benefit to know that if reasonable grounds are found, there is a separate notice that is generated called a statement of matters asserted. That's in a more formal complaint that will outline both the factual and legal basis for moving forward that will be given to Mr. Oxendine. So even if the form of this commission's finding of reasonable grounds is not perfect in form, so long as it captures the substance, the form will be perfected in the notice of the statement of matters asserted that is then filed to begin the proceedings in OSAM.
Got it. All right, any discussion on the pending motion? Mr. Commissioner Barnard, do you want to give your input on the addition of 33A?
Sure. 33, as I read it, talks about contribution to a candidate. It specifically states that a campaign committee or a public officer holding elective office and any proceeds from investing such contributions shall be utilized only to defray ordinary and necessary expenses, which may include any loan of money from a candidate or public officer holding elective office to the campaign committee of such candidate or such public officer, incurred in connection with such candidate's campaign for elective office or such public officer's fulfillment or retention of such office. The evidence presented by the staff, and particularly Mr. Lane, suggests to me that the funds that were used or that were transferred from Oxendine working for Georgia to Oxendine PC were not utilized to defray ordinary and necessary expenses of the campaign, but were in fact used for other purposes, including personal purposes of either Oxendine PC or John Oxendine himself. And I would also add that, at least in this commissioner's view, based upon the evidence that we present, is what leads me to that finding of reasonable grounds in the absence of any evidence that it was used for something else.
Any commissioners have any thoughts? But my only thought on this one is whether or not this has to be an expenditure.
I'm not following the expenditure.
Yeah.
And let me offer a little more clarity. I don't see any evidence to suggest that these funds were used to defray ordinary and necessary expenses of the campaign. They were used for other purposes, which would be a violation of 33A.
Well, commissioners, any other discussion? All right, hearing none.
Well, let me, so to Commissioner Barnum's amendment, and I know I raised this earlier, but if you look at 21-5-3-18, the ordinary and necessary expenses piece, which we're discussing, amendment, does refer to expenditures and then follows with a bunch of qualifying expenditures. The definition of expenditure is in subsection 12, which is broad in terms of purchase, payment, distribution, loan, advance, deposit, or any transfer of money, but it does have limited purposes. And just looking at this now, I'm not entirely sure that any of these purposes based on the evidence we saw today, were what the funds were used for. Whereas, I know I'm skipping around, 21-533C, the initial motion, I think is clear.
Commissioner Watergate, I'm not understanding your comments about 33A and 21-5-3. You mentioned 18,
Yeah,
which is ordinary and necessary expenses.
right.
Are you suggesting, do you think that it meets
No,
the
what
expenses? Okay.
what I'm saying is I think ordinary and necessary expenses, that definition in 18, is limited to expenditures. So all the way almost to the right here, shall include, but shall not be limited to expenditures. And then
Right.
there's a number of qualifying expenditures below. Then, to go to the definition of expenditure, and this is under subsection 12, just skip to the end of the first line where it says transfer of money. So that's very broad. But underneath that, it says for the purpose of a number of things. I don't think the funds in this case, at least how it's been presented today, were used for any of those qualifying events under the term expenditure. So whereas I think the initial motion was to accept moving forward with the grounds of 21-533C, and that is limited solely to the way in which contributions may be utilized. And so that's, I have a little bit of heartburn moving forward with 33A versus solely on 33C. And I just laying that out there.
Well, here it seemed to suggest that a loan is a proper expenditure, right? But
Yeah, I think it does, and I saw the same thing too, Mr. Commissioner, and for me, I'm not buying that this was a loan.
And Commissioners, without interrupting your proceedings, the commission staff's argument that it's not a loan, it's a transfer, it's an expenditure. Mr. Oxendine is the one who's claiming it's a loan. We've never conceded it's a loan or an investment.
And I'm, based on the evidence presented today, and I'll say this, I think my question suggested it, I'm not buying the argument that it was either a transfer or an investment or a loan. I think that the evidence suggests that the Oxendine campaign gave money to the law firm, and the law firm then transferred that money to Mr. Oxendine and he used it for personal purposes.
All right, any other comment from the commissioner?
On the expenditure, definition of expenditure, it's saying, made for the purpose of influencing the nomination for election or election of any person. Well, there was no pending election. Elections were over, which is different than the disposition of the contributions. So the actual definition of 21-5-3-12 looks like it may only be if there was a intended election coming up or a recall to be referred through.
Yeah, well, my thought is, Mr. Oxendine will have an opportunity to present evidence to show it was indeed a loan. I think it's a reasonable grounds of termination today. And my thought is, I think reasonable grounds have been shown that A can be included. But any further discussion?
I would, to Mr. Fuller's point, I think this is going to be perfected, but my preference would be to have a vote on A and have a vote on C.
We can do that, and so I can withdraw the amendment, and then we can have a second.
I think that's fair.
Second motion.
So we've got a pending motion to find that there's reasonable grounds to believe that OCGA 21-5-33C has been violated. We've got a second. Is there any further discussion? Hearing none, I'll call the question. All in favor say aye.
Aye.
All opposed say nay. The motion carries unanimously 5-0. So I think Mr. Barnum, if you want to make a motion.
Yes, Mr. Chairman, I move that this commission make a finding of reasonable grounds that Oxendine working for Georgia violated OCGA 21-5-33A when it made 2013 transfers of, I forget what the numbers are, not $97,000, $50,000, and $40,000 from Oxendine working for Georgia to Oxendine PC's IOTA.
Okay, we got a motion, do I hear a second?
Second.
We got a motion and a second, any discussion? Hearing none, I'll call the question, all in favor say aye.
Aye.
All opposed say nay. So the motion carries 4-1. Commissioner Watts is the only one that opposed. All right, so Mr. Lane, if you could tell me what you're thinking on proceeding. We're definitely going to take a lunch break now, but I think before we take a lunch break, it'll be helpful to know in the afternoon what the procedure is.
Yeah, excuse me, Mr. Chairman, I believe that we've got to still deal with, those were allegations, I think got limited to 2013 expenditures, or transfers rather, and so now we've still got to do the calendar year 2014,
Okay.
which is allegation 2.
Oh, okay. Oh, we're still going to take a lunch break.
No, I mean, just for the purposes of making a motion.
Okay.
I mean, I think all the evidence and the argument was already made with respect to it. We just need to go ahead and.
Oh, got it. So that was limited to one. Okay.
But it's moving forward in the exact same way.
Sure. All right. Well, I guess we need to specify on the record as well. So I'll make a motion for calendar year 2014 that there's reasonable grounds to believe that OCGA, or Mr. Strike that for calendar year 2014, there's reasonable grounds to believe that Mr. Oxendine violated OCGA 21533C. If I can get a second.
If I may amend,
Sure.
that let's just to make it clear that Oxendine working for Georgia is the respondent here, correct?
Yeah, so I'll second that amendment. And any discussion? Hearing none, I'll call the question. All in favor, say aye.
I don't think we got a second on the motion.
I'll second the
Yeah,
motion.
right.
Well, I think I seconded his amendment.
Right.
Okay, good. It's a C. So we got a second, and Mr. Barman made the amended motion. Commissioner Watt seconded. Any discussion? Hearing none, we'll call the question. All in favor, say aye.
Aye.
All opposed, say nay. Hearing none, motion carries 5-0. Mr. Barman, if you want to make a motion?
Sure, I move that this commission find reasonable grounds to believe that Oxendine working for Georgia violated OCGA 21-5-33A when it transferred $50,000 in 2014 from Oxendine working for Georgia to Oxendine PC's IOTA.
All right, we got a motion. Do I hear a second?
Second.
All right, we got a second from Commissioner Thompson. Any discussion? Hearing none, I'll call the question. All in favor, say aye.
Aye.
All opposed?
Nay.
So motion carries 4-1, and Commissioner Watts opposed it. All right. Vice Chair Cranville, anything else? You looking out? All right, so Mr. Lane, if you could talk about the format this afternoon, what's left?
The format will be similar to what you have already endured, but it will be shorter. Because the facts are much simpler because we're not having to trace funds. They're just apparent, it's more of a legal argument for both. Allegation 3, which is the spending of restricted funds. We're arguing that certain funds were restricted because they were elections that Mr. Oxendine did not qualify for. Allegation 4 is related to exceeding maximum contribution limits by a affiliated close action committee. So it should go much faster.
Are you going to combine those two, or are those going to be separate?
Do you prefer they be separate or combined? I can do it either way.
I think I prefer them separated. I would, so we can, I think separate.
They're different legal issues. I think they're rather than confusing the issue.
Okay, well, let's do a 30-minute lunch. Reconvene at 1:30. I look forward to seeing everyone there. We'll adjourn the meeting.
Correct. We're not alleging that we misspent primary fund money.
Okay, so we're only dealing with 21-543D.
Correct.
Okay, then we can make a motion perhaps on that basis.
All right, well, I will make the motion to dismiss the allegation and complaint as to OCGA 21-5B.
Mr. Chairman, rather than, because the complaint itself alleges different allegations, different statutory provisions, including C, I'm not sure that that actually does the job. I think the way it probably needs to be structured, and Robert and I can come up with an appropriate order, but is to dismiss the allegations contained in paragraphs 38 and 39 of the amended complaint filed by the staff in September of 2015, which is the only allegation that has survived to this point in that complaint, which would leave no other allegations remaining except the one asserted by Mr. Anderson back in 2009 in that case.
Could it alternatively just be a motion that there are no reasonable grounds to believe?
Or you could do that.
That would be the easy one.
That's what I was, yeah.
Okay.
A little bit tired.
I'll make the motion. Well,
Go ahead.
is there one on the floor?
And we're still dealing with allegation 3, correct?
Correct.
Yeah, make an amendment. Go ahead.
I'll amend the motion to the extent it's on the floor, just to find that there are no reasonable grounds to find that the respondent improperly expended $208,067.51 in campaign funds, which were allocated for elections that responded allegedly failed to qualify under campaign for the violation of the only remaining allegation being OCGA section 21-5-43D.
Seconded.
We've got a motion and a second. Any discussion?
So let me just point this part out. I mean, because our burden of proof is so low on this, and we're just looking for reasonable grounds, because of the inconsistency on how qualifying is being applied throughout the act, I think it's important for us to, because this is going to change, we're going to have to address some administrative things on how people are going to report if this is the way that, if this is going to be the commission's policy. And I just can't see how we don't have enough for reasonable grounds to really get into the weeds on this.
I mean, if I may, and I don't disagree with Commissioner Thompson that may well be a result. But I am convinced by an argument made earlier today that this is quasi-criminal. And when you're talking about that type of statute, a reasonable ground for me needs to be more than a possibility or an interpretation. It needs to be something that I'm convinced is a violation, or at least, I'm not comfortable dealing with the.
That's not what it says. Doesn't it say reasonable grounds to believe?
Right, and I don't believe that section D applies in this circumstance, because I don't believe that the term qualify, as the staff is suggesting it, is the proper definition under these circumstances.
All right, Commissioner Watts.
If anything has taught me in my first year on the commission, especially my experience today, is that we will greatly need the assistance of Secretary Lottie to clarify some of this legislation and to speak with the legislature to make some of these issues more clear. But I will say, even before we move to the next section, thank you to both of you, because you've done a fantastic job helping clarify and put a magnifying glass on some of these problems.
Okay, good. Any further comments? All right, hearing none, I'll call the question. All in favor of the motion, say aye. Aye. All opposed, say nay.
Nay.
All right, the motion carries 4-1, and Commissioner Thompson was the lone opposition, so good. So are we ready to move forward for the next session? Do the commissioners need a break? We're good to keep going? Okay, good. Mr. Lane, are you ready?
Yes, sir. Just 1 second and I'll switch over.
Mr. Chairman, could I have 2 minutes to run the restroom?
Yeah, we'll take a 5-minute restroom break.
Sorry.
Are we ready?
We're ready.
All right, we'll call the meeting back to order. And Mr. Lane, for the record, you're going to be presenting, is this your last?
This is the last one.
All right, good. We're ready.
Commissioners, you have allegation 4 in front of you, which is the allegation that Mr. Oxendine improperly exceeded maximum contribution limit pursuant to 21-541, and that he received $120,000 from 10 affiliated political action committees. Just so you're well aware, Mr. Thomas and I are going to be arguing about two various provisions of the code. We contend that one provision controls, he contends that another provision controls. But before we get there, I need for you to understand the distinction between two terms that you're going to see ad nauseum in this discussion. The first is business entity, which is defined in 2153. It's the very first one in our definitions. It's on the screen in front of you. It's slide number 59 in your presentation. A business entity is defined as any corporation, sole proprietorship, partnership, limited partnership, limited liability company, limited liability partnership, professional corporation, enterprise, franchise, association, trust, joint venture, or other entity, whether for profit or nonprofit. As in all things with campaign finance, it seems deceptively simple. You next have political action committee, which is defined as any committee, club, association, partnership, corporation, labor union, or other group of persons which receive donations during a calendar year from persons who are members or supporters of the committee and which contributes funds to one or more candidates for public office or campaign committees of candidates for public office. Also includes a separate segregated fund, which we don't have to address. That definition is contained in 2153 subsection 20. Moving along. This is where these definitions are actually contained within the maximum contribution limit code section. So they're outside of 2153. An affiliated committee, which is what we're going to argue that happened in this case, are any two or more political committees, including separate segregated funds, established, financed, maintained, or controlled by the same business entity, labor organization, person, or group of persons, including any parent, subsidiary, branch, division, department, or local unit thereof. That's 21.540, subsection 1. You then have political committee, which again, it kind of repeats the definition you had in 21.53 for political action committee. That's a little different. Any partnership, committee, club, association, organization, party caucus of the House of Representatives or Senate, or similar entity other than a business entity. So it specifically excludes, in the definition of political committee, a business entity. That definition should be jettisoned from it. Or any other group of persons or entities which make contributions in separate segregated funds. Now to the fun part. What we maintain, the operative law, there are two provisions that control aggregation of contribution limits. So if you're basically having to determine a business or a political committee, how do you add their funds together if they're related to one another to see if they're violating the maximum contribution limits? And as you will remember, Mr. Oxendine's limit was $18,800 during 2008. What we have here is the first section is A, which is what we're claiming controls, 21.541A, that no person, corporation, or political committee or political party shall make, and no candidate or campaign committee shall receive from such entity contributions to any candidate which exceed the aggregate limit for the election cycle in question. Now, of course, I've included the brackets to show that it's $5,900 because, as you know, the actual code says $5,000, but then the rules allow for it to be increased because of inflation. I've just included that it's $18,800 for the period of time in question. And so what it's saying is for affiliated political committees, if they are related, you aggregate them together, and it's treated as one big donation, and that's applicable to the contribution limits. Mr. Oxendine is going to argue that 21.541C controls, and that states that no business entity shall make any election contributions to any candidate which when aggregated with contributions to the same candidate exceed maximum allowed contribution limits. Now what you'll notice that's different between A and C is that C does not have the same language where it says, and the candidate shall not receive. So Mr. Oxendine's defense with C is that if a business entity made the donations in the aggregate, you can only punish the business entity. So for example, if Coke Industries and Georgia Pacific, because Georgia Pacific is a wholly owned subsidiary of Coke Industries, both wrote a check, say for $50,000, like combined, to a gubernatorial candidate, that would violate maximum contribution limits, but we could only punish Coke Industries and Georgia Pacific for making the donation. You could not punish the candidate, and I think that's true. However, subsection A for a political action committee, you've got the people who love Georgia, the people for a better Georgia, and the people that want Robert to win. They're all PACs. And they all donate money, and it all comes up to $50,000. You have to also aggregate those funds because they're controlled by the similar entity. And it really doesn't matter how it's controlled, but let's just presume that all three PACs are really, Mr. Amati's controlling all three PACs. You aggregate them together. Now, in that instance, you could punish Mr. Amati and the three PACs, but you could also punish me, the candidate, for taking the funds. So that's where our distinction lies. Now, for the allegations here. In 2008, Mr. Oxendine took a number of donations, and they all came from 10 affiliated PACs. Cash and Check PAC, Courtside 10 PAC, First Highland Avenue, Georgia Dome, Lift PAC, Peachtree PAC, Phillips PAC, South Perry PAC, Turner PAC, and the Watkins Groups PAC. And they all donated their money on the exact same day. On September 25th, 2008, all 10 PACs gave $2,000 to Mr. Oxendine. On December 31st, each PAC gave 2 separate transactions of $5,000 each for a total of $10,000, all on the same day. And it gets more interesting than that. All 10 PACs were chaired by Mr. Donald B. Watkins, Jr. All 10 PACs retained Ms. Sharon Long as treasurer. All 10 PACs were registered with the Alabama Secretary of State's Political Action as a political action committee pursuant to the Alabama Fair Campaign Practices Act. All 10 PACs shared the exact same mission statement and purpose: to stimulate a higher level of accountability and interest in pocketbook issues by promoting independent voting throughout the state. All 10 PACs used Al America Bank, with Mr. Donald B. Watkins and Ms. Kimberly Perkins as the signatories to the accounts. And all 10 PACs made exactly identical donations to Mr. Oxendine on the same day, by the same person, drawn on the same account, and in the same amount. In fact, I haven't included the checks in this presentation because, unfortunately, Al America provided checks about copies like the ADA, so there's not a way to really blow them up for you, but they're all signed by Mr. Watkins on the same day, same amount, written exactly the same. And then what you have going forward on the screen is you have the Alabama Secretary of State's registration for each one of the PACs. They share the same chair, same treasurer, same phone number, same address, same mission statement, and it also, their expenditures are to the left at the bottom. And all 10 PACs show the exact same transactions on the exact same day. And if you look at the contributions, which are not included in these slides, they come from the same entities. They come from Admiral Life and State Mutual. So there's no contention that the PACs are controlled by other entities, that they're somehow not related, not controlled by similar entities. So for all intents and purposes, they are affiliated. So really you have to determine, do you find subsection A controls or does subsection C control? And if you want, I can go through the remaining 10 slides, but it just says the same thing over and over with the PAC name change. And that's it for allegation 4, Commissioner.
Mr. Chalmers?
I think I got the figure, yes, sir. Remind me again how to make this big. It's non-existent. There you go. Thank you, Commissioners. Our argument on this one's going to be even shorter than the last one. And the bottom line is you've got the wrong party before the Commission. The statutes that apply here with respect to affiliation only apply to donors. They do not apply to candidates receiving contributions. And we'll talk about the actual statutes here in a second. But I think that First off, the natural question pops up, well, why would that be the case? Well, it's simply the case for an obvious reason. The General Assembly did not, apologize. The General Assembly did not want to impose on candidates the obligation of determining which one of their donors were affiliated with the other donors. That's something that the donors know. And so therefore the law, when it talks about affiliation, says that no entity may make contributions when affiliated corporations also make contributions that together with it exceed the limits. It does not say anything at all about affiliation in the provision of the code that relates to receipt of contributions. Now, this is another badly drafted statute. Mr. Lane cited two terms. One was the definition of affiliated committees. It's defined in the code, it's not used anywhere in the code. The affiliated corporations provision is used, but it's only used in one place. What the use of these affiliated and drafting of the language about affiliated corporations makes clear is that the General Assembly knew about the concept of affiliation when it drafted the code, and it knew where it wanted to use it. Affiliation basically means at the most basic level under common ownership or control. There are a number of definitions, but it basically means that I can't go out and set up 5 different corporations that I all control, and each one of those corporations goes out and makes contributions to the same candidate that exceeds a limit. But it doesn't say anything about affiliation with respect to the receipt of the contributions, and that would, to do that, would impose an unreasonable obligation on candidates, and the General Assembly chose not to do it. So let's take a look at the provisions that use the language affiliated corporations in it. And remember, that's the only term that's used to discuss affiliation. Every single one of these provisions, both in the Act and the Commission's rules, refer to the making of contributions. And the legislature also differentiated in different provisions about making and receiving. They knew the difference and they knew where they wanted to apply it. 41C, no business entity shall make any contributions which, when aggregated with contributions to the same candidate for the same election from any affiliated corporations, exceed the per election maximum limit. What's missing from that? No candidate shall receive contributions from any business entity that, when added together from contributions from affiliated corporations, violate the limits. It's not in there. Same thing applies for the Commission's own rules. 189-6-.03. No corporation shall make contributions that are exceeding the limits when you take into account affiliated corporations. The Commission adopted that rule pursuant to the statute. Same thing. 189-6-.04, maximum allowable contributions by political committees, Commission's rules, only refers to affiliation in the context of making contributions. The provision that Mr. Lane is citing and that Mr. Anderson cited in his 2009 case does not include anything about affiliation. It's not in there. No person, corporation, political committee, or party, those are very specific entities, shall make, and no candidate or campaign committee shall receive from such entity. Doesn't say from that entity any affiliated entities with it. From that entity, an excessive contribution. Candidates are entitled to rely on the fact that they receive a contribution from an entity that's within the limits. They have no obligation under this code, and it would be unreasonable to impose one to make them look behind that and see whether or not the contributors who gave money to them were affiliated. That is why the Act solely opposes that obligation on the donors. This allegation should be dismissed as a matter of law. And I want to point out to you also that that's exactly what the first staff attorney who handled this case back in 2009 said. In the investigative report that is attached to your file after Mr. Anderson filed his complaint, Tom Plank put together an investigative report. I assume he was assigned to do that by Mr. Thompson. That investigative report says right here, although the Act prohibits affiliated corporations from making contributions that, when aggregated, exceed the limits,
does not prohibit a candidate from accepting contributions from affiliated corporations or committees that, when aggregated, exceed the limits. Now, Mr. Lane and I have disagreed about this. He thinks that, and I think it's clear, that is not binding on the commission. That was one of your staff attorneys, and you now have other staff attorneys telling you different things. But at the very least, my interpretation, which is consistent with one of the commission's own staff attorney's interpretations, is reasonable, fair, practical, has an intelligent rationale behind it, is consistent with fair principles of construction, and even without construing the statute in the light most favorable to Mr. Oxendine, as must be done, this allegation fails to state a violation of the Act. And we respectfully request that this allegation that was originally raised by Mr. Anderson and restated in the Commission's amended complaint be dismissed.
Mr. Chalmers?
Yes, sir.
Go ahead, Commissioner Watts.
What, I told you I didn't want to be esoteric about the last case, let's be esoteric about this case. Is there a difference between receive and accept? I mean, what if you know like, I see this, they can't receive it, but is that the same meaning as accept? It might be to you, which is fine.
I believe is a matter of, receiving, I'm not sure it's a distinction in the law that matters. The Commission's always taken the position, if you get a check and you don't accept, you don't deposit and refund it, then you don't have to put it on your disclosure report. So maybe that's different.
Mr. Lane, a question for you.
Yes, sir.
I'm looking at 21-541. It doesn't state affiliated organizations, which Mr. Chalmers argued. How do you get to the application of 21-541A, or am I misunderstanding the staff's position?
You're not getting to a misunderstanding. It is, we are arguing that in reading 21-540, where we define, or the legislature defines affiliated committees,
Yes.
it is providing a definition for us to judge when, in fact, a political committee is affiliated for purposes of aggregation. And so that you're treating, they're basically alter egos of one another. And I would submit to the commission that the reason you have A and C, because also when you're doing statutory construction, you're to presume that the legislature didn't intend to have a provision that was a mere nullity. And sort of like last time, if you adopt that the business entity, C, is controlling for the only aggregation, then you're jettisoning certain other provisions within the code. And this commission has also ruled before in other cases, I affectionately call them the Stambaugh cases, in which you have 3 corporations, all controlled by a gentleman named Mr. Stambaugh. And the difference in that case is that the commission ruled that they were not affiliated entities because Mr. Stambaugh did not have voting control. He had to convince others to go along with him. And so each corporation was treated as independent. And the reason I would submit to the commission that the reason the legislature carved out business entity and gave it its own subsection C, aside from political action committees, is because a member of the public can find out who controls a political action committee. It took me all of 15 minutes to find the Alabama Secretary of State's registration for all 10 PACs to see who was controlling it. Whereas for a corporation, it's almost impossible to know who's controlling that corporation unless you have subpoena authority and you can actually pull back their corporate minutes and see actually who's driving the bus, so to speak. Whereas in the PAC context, it's easily available for members of the public, and I don't think it is unreasonable for candidates when they receive 10 different contributions, and in this one it was actually more than 10, it was actually 30 contributions, from similar PACs that are all at the same address. They all come from the same address. They're all going on the same bank. They're all signed by the same guy. They all have the same mission statement. It's not unreasonable for a candidate to presume that those are affiliated committees. It's the exact same entity.
Yeah, and I agree with you on that, Mr. Lane. I think there's reasonable grounds to believe that these are at the least under this common ownership or control. The question to me comes down to whether it's on the candidate to determine if affiliated corporations in the aggregate exceed the maximum contribution limits. And so how do we, with what Mr. Chalmers just said, in a lot of other sections, it does expressly mention affiliated corporation, and in this section it doesn't. How do you respond to that?
It does mention affiliated corporation in subsection C. I'm not alleging a violation of 21.541C.
What? Say that again?
20, when you have to affiliated business entity, that's 21.541C, where it says no business entity shall make an election contribution when aggregated together. I'm not alleging a violation of 21.541C.
I know, how does that help your argument then?
Because I can see that if a business, if Koch Industries and Georgia Pacific both write a check, that the only people we can punish are Koch Industries and Georgia Pacific. I can see that. I've never argued it otherwise. What we're saying is here, they were political action committees, not business entities. They weren't corporations, it was a PAC. It was 10 political action committees, so it falls under the definition of political committee, because if you'll notice, they don't use the term political action committee. They use the term political committee, which you refer back to political committee, which throws in the definition of political action committee.
Definition of, okay.
Yeah.
So you're telling me that the political committees, now I forgot their name, but it was 10 of them or something.
Yeah, there's 10, it's like Cash and PAC, Live PAC, Georgia Dome PAC.
And they're not affiliated. I guess I'm having a hard time understanding, are each of these political committees, I mean, the section you're proceeding under doesn't use the word affiliated, so we've established that. And now, are each of the political committees above the...
I'm saying the political committees are all one organization that use 10 fictitious names in order to be able to go around the maximum contribution limit.
Yeah, I mean, this is another policy argument.
Yeah.
I mean, what this is, I mean, it's clear this was an effort by this gentleman out of Alabama to get around the maximum contribution limits. And so, again, I guess that Mr. Chalmers says that, the question here is, who's on the hook for that? Is it a candidate, or is it just the gentleman that was the one that was trying to subvert the maximum contribution?
But the commission should also be, may I address a factual matter?
Sure, but actually, just please give me 1 second. I guess the idea here, though, is that, I mean, yes, who's on the hook, but, I mean, did he do it legally? I mean, whether or not we have the right party or not. I mean, this is not, the legislature wrote this like they wrote it. And unless, I think you're saying each political committee, which in this case would be Cash and Check, Courtside, First Highland, Georgia Dome, and so forth and so on, were over the legal limit, then I'm not entirely sure that 21.541A has been violated. And if I'm misstating any of that, that's just how I'm hearing it. So please correct.
And I know you want to say, but I just have a quick question for you.
Sir.
Is your argument, Mr. Lane, to an extent that the 10 of these groups in and of themselves were actually one political committee?
Correct.
Okay.
Just a factual note, 2 things. The commission did in fact attempt to go after the donors years ago, and they had extensive litigation on that issue. And in 2014, the commission decided to drop those allegations and simply go after Mr. Oxendine. So there was a case against the donors. The commission was attempting to pursue it, and they dropped it. And a lot of that was because of Mr. Ritter's desire to keep this case against Mr. Oxendine moving forward.
What about this? And I'm not ignoring what you just said on the
Yes, sir.
factual issue, but up in the definition of political committee, it says any partnership, I'm under A, any partnership, committee, club, association, organization, party, caucus, of the House of Representatives, or the Senate, or similar entity other than business entity, or any other group of persons or entities. And it uses entities there in the plural. So doesn't Mr. Lane's argument make a little sense that you can actually have separate entities that could be characterized as an individual political entity, such as what we have in this case?
Except that if the legislature wanted to make it clear that the contributions from those entities would be aggregated, that affiliated, then they would use the affiliated language just like they did in the making provision.
Yeah, but they don't need to have it aggregated, right? Because if a political party, and all of these entities qualify as a political party, in aggregate, make a contribution that exceeds the minimum contribution limit, you're in violation.
Correct.
Yeah.
Right. And if I may, so a political committee, if it is a group of persons or entities which makes a contribution, and these groups of entities made contributions and, I guess, $2,000 contributions as a group. I mean, Mr. Chalmers, can you talk about that a little bit?
I think that that's inconsistent with the statute. I think that yes, it has multiple entities in it, but I think that also would, if the legislature wanted to include affiliation within that and impose an obligation on the candidates to know which ones were affiliated, it would have specifically used the language on affiliation that it used in 41C.
But you don't need that here. Because again, it's written in the plural.
Correct.
You don't have to go to affiliated committees. You've got plural entities in the definition of political committee. And I personally think that, there's overwhelming evidence here that, this was just an effort to subvert the maximum contribution limits.
Well, and if I may, and I can anticipate Mr. Chalmers, perhaps the argument might be, well, is it on the candidate to know? When you look at the evidence, all of the contributions came in on the same day, drawn on the same bank, with the same people and the same amounts. It doesn't take a rocket scientist to know that this was coming from the same people.
I still interpret the statute differently. I think they would have, if you start assuming that any group of persons or entities which makes a contribution, it also speaks in terms of a contribution. There were multiple contributions from multiple different entities, and I believe that the code is designed to allow candidates to rely on the fact that a political committee gives a contribution, it's one entity. Mr. Lane has also, in his factual presentation, been a little inconsistent. He said, yes, in answer to your question, this is one political action committee or one political committee. In his statement today, just earlier, he said there's 10 political committees. So if there's 10 political committees, then Mr. Oxendine did not accept an excessive contribution from any one of those political committees. The political committee definition is, by nature, designed to come. A committee is something where people band together and make contributions through an entity. For example, that's what a political action committee is. That's what a political party is. And many political action committees are incorporated. When the PAC accepts contributions and makes contributions, that's the political committee. That is the group of entities and persons who is making the contribution, which is referred to in the code. That is a much more reasonable interpretation than all the different political committees that were owned by this one individual, if that's the case, are one political committee. And again, I think saying that they are one political committee when there are in fact 10 separate PACs is
10 separate entities.
10 separate entities, yeah. So how can
I think if you read I have two thoughts. My first thought is, and it isn't on us to make this determination, but if I have 10 PACs chaired by the same person with the same treasurer, all from Alabama, there's a likelihood I know. I mean, there's a likelihood that I'm aware that there could be some circumstances.
But as a legal matter, that you have an obligation to know. Let's say, Mr. Lane was talking about the parade of horribles before. Let's go down that path. Let's say that there is a candidate who's working his tail off running for office, and he gets contributions from 4 different political action committees and they are in different dates and different amounts, but they're all relatively close together. And then it turns out somebody files a complaint with the Ethics Commission and says, you are under obligation to conduct an inquiry. Figure out whether the boards of directors and the officers and the treasurers matched up. Figure out and look at the addresses. And we then have a series of complaints against candidates who were not able to determine, or reasonably or quickly, whether or not somebody was affiliated.
And I get that, but we're not unaffiliated right now. We're
I know,
looking at just political committee.
Were they entitled to presume that each one was a separate political committee?
Well,
That's not, I guess, to the Chair's point, that's not on us. I mean, I agree that this legislation needs to be changed. I mean, there are updates that need to happen to this legislation.
No question.
But, I mean, to Mr. Crandall's point, you know, when you do look at it as group of persons or entities, which makes a contribution, and I understand that it's a singular contribution, but the 21.541A speaks of contributions in the aggregate of a political committee, which here is, you know, to me,
I think that we also need to look at the fact that the law does not use the term affiliated committees, which talks about two or more political committees financed, maintained, or controlled by the same person. That necessarily means that each one of those political committees is the political committee. It is not the overall affiliation, the overall entity that is the political committee. Those are affiliated committees. And so what this means when it talks about the political committee that you may receive contributions from as a group of named persons, the commission has in the past, for example, just to explain the group of persons issue, an independent committee in Georgia cannot be a single person. So the language of a group of persons acting together to form a committee necessarily is consistent with Georgia law that basically means there must be two or more people acting together. That is a PAC. That is what they do. And that is what this political committee would be. When you say in 41A that the candidate can only receive a certain amount from the political committee, it's basically the entity. If in fact the legislators wanted to make it affiliated committees, in other words, if they had wanted to say you may not accept contributions from affiliated committees that exceed the limit, they would have used the term in 21.540-1, which talks about two or more political committees. Mr. Lane's argument is basically taking the position that the affiliated committees in this case were one political committee. That's not correct. The affiliated committees would have been the affiliation of the 10 different political committees. If each one of those is a political committee, and Mr. Oxendine accepted the limit from each one of those political committees, he complied as a matter of law with 41A. And again, we go back to, is that a reasonable construction of the statute? Absolutely. Is it the one that most comports with his rights? And the answer is yes.
Well, let me ask you then, what is, to your independent PAC scenario?
Yes, sir. Independent
Committee, sorry. What is the same true for a group of entities? Because you were using an example with a group of persons. I assume it's the same scenario, it'd still be an independent committee with a group of entities.
Well, you could have different entities form together to form a PAC. Yes, you could. You could have, for example, you could have a political action committee that is a LLC or that is a corporation, and you could have members be other entities participating in that. Sometimes you do have political action committees band together to form another political action committee, but it still would necessarily be one entity. Otherwise, this affiliated committees term at the top makes no sense, even though it's not used.
And I appreciate you keep going back to the affiliated committee. I think that the commissioners here focus on the definition of political committee, and it talks about groups of persons or entities. And
Right.
this group of entities, if you will, is controlled by a single person.
But that's also why it is a single contribution. When they're talking about a committee being a group of persons or entities that bands together to make a contribution, the political committee is necessarily making a contribution. What affiliated committee says at the top is if they band together to make multiple contributions through two or more political committees, and that's the key phrase, that phrase alone resolves the issue. Affiliation is two or more political committees, so that means the political committee is one that makes a contribution.
So if I'm understanding your logic, I'm sorry, Commissioner Locke, but
Yeah, go ahead.
if I can understand your logic, so this group of entities, by your logic, had they made individual contributions that exceeded 18,800 and the Oxendine campaign accepted those, then we could hold the Oxendine campaign.
I'm sorry, I lost you, sir.
Sure. If each one of these 10
Each one of these 10
had made a campaign contribution of $20,000.
in excess of the limits?
Correct.
Yes, then each PAC would be in violation of the law because they have each violated the contribution limits
Okay.
as a PAC.
But if I'm understanding your argument is that because they each made contributions of $2,000, even though it's obvious to anyone, it's the same person, that the Oxendine campaign had no obligation to comply with the statute?
No, yes.
And not accept the money under 21-541A?
He was entitled to accept the money within the limits from any person, corporation, political committee, or political party. If I understand you correctly, you're saying that all of the contributions were within the limits? And that's exactly what happened here
Well,
anyway.
if you believe, if you take the argument that each individual PAC
Yes, sir.
made an argument and made a contribution within the limits, and there is no way for the Oxendine campaign to have known that they were affiliated, then perhaps your argument, I think you might have some support, or at least I might get it. But from what I look at, there isn't any way that anyone will look at these contributions and not know that they came from the same person on the same day in the exact same amounts.
But that's sort of getting us into a summary judgment standard rather than a 12B6 standard. My argument is tantamount to a motion to dismiss on the grounds that this fails to state a claim under the law. And I think you have to actually, in deciding that, not look at the facts about whether these were in fact affiliated corporations or who should have known what. The basic question is, did he have an obligation? And do candidates in Georgia have obligations? If in fact, and I think that from a legal perspective, from a policy perspective, the legislature has made it clear they do not want candidates to have that obligation. If you say otherwise, we're opening the door to some significant amount of complaints. The legal issue, getting directly to Mr. Lane's point about what the political committee is, he relied on the definition of affiliated committees. And the whole concept of affiliation is more than one entity gets together and bands together to make a contribution. This says an affiliated committees is two or more political committees. So what that means, and especially when you talk about political committee being a group that makes a contribution, I think the political committee here, for purposes of 41A, must be each individual PAC which made a contribution through a group of persons or entities, rather than the affiliated committees. You can't say that the affiliated committees are one political committee, because the definition of affiliated committees specifically talks about it being more than one political committee. I think legally, when you're trying to analyze whether or not he violated the law by receiving too much from a political committee, entirely separate from the fact that there's no affiliation language in 41A, as a matter of law, our contention is each one of those PACs was a political committee. If they were affiliated, they would have been affiliated committees. But even that says they are two or more political committees, which means we're talking about a contribution from each one. He was, as every other candidate is, entitled in Georgia to accept a contribution from an entity, a political action committee, a corporation within the limits, should not have, and the legislature did not want to require, that they go behind that and make a determination of whether the donors exceeding limits, even in circumstances where it may seem obvious.
So, all right, so back to should or should not the candidate know. I wholeheartedly believe that that is a policy question that can be addressed, not here. But I guess if I'm looking at, and I understand what you're saying, Mr. Chalmers, about these are 10, well, if Mr. Lane said earlier these are 10 political committees, okay? And
They may be affiliated committees.
then, so you're saying that A, because they're affiliated, because it doesn't use the word affiliated.
doesn't use the word affiliated, but I think the definition of affiliated committees that Mr. Lane cited also gives the lie to his argument that the affiliated committees were the political committee. Affiliated committees under that are 2 or more political committees. Again, what can Mr. Oxendine not do? He cannot receive in excess of the limit from a political committee. So if 2 or more political committees, like each one of these PACs banded together, they would be affiliated committees, and it would potentially be a violation of the law for the donor to make those contributions. But the political committee is not the affiliated committees, it is each individual PAC separately. Georgia candidates are entitled.
So I understand that.
Yes, sir.
Where is affiliated committee used in the statute?
It's not.
Okay.
It's
That's
defined.
not necessarily defining for me, because I mean, it is in the statute.
It's in the statute, and I think it can be used for interpretation on what the political committee would be, and it would have to be each individual PAC, which is still a group of persons or entities, because otherwise it wouldn't be a committee at all. But I don't think it is odd that it's not used.
So each of these is listed as a PAC. Yeah, they're all PACs, right? So that
Each one of them is a political committee, is a PAC, yes, sir.
Sure, and so that gives them some of a formal status as a political committee, right? I mean, that's
Yes, sir. And each one of them made a contribution, which means that's a political committee.
Okay, so there's no denying that, all right, they've got a formal registration as a PAC, but I guess I'm trying to figure out this group of persons issue, because I am hearing you on the ambiguity of this, and it does, Mr. Lane's evidence does lend towards the affiliated committee status, at least as I'm reading this. So how can we have, again, you mentioned an independent PAC. I still think that that's a formal status, right? That is a PAC. But how can you have a group of persons who makes a contribution and I mean, like, how is that defined as a political committee? Just a group of persons? Because there's the 2 people that control all of these entities. That to me is a group of persons. But
the phrase group of persons and entities is, it's more common to have a group of persons than entities, but it is a common language in campaign finance law, which is designed simply to differentiate it from an individual. And so, for example, the reason I brought up the independent committee example, when we start talking about committee, it can't be one person under Georgia law. And so therefore, when we start having 2 or more persons, that's how the law defines an independent committee. And so when you see this definition of a political committee here in this provision, they're basically paralleling that same language that's used in federal and state campaign finance law a lot. A committee is a group of persons. Committee can be a group of entities too. If a group of entities put together a political action committee, you could have a trade association, for example, a chamber of commerce, which has lots of entities in it, and set up a PAC for the entities. So that would be the committee. I think what we get back down to is the law says that the candidate may not receive more than the contribution limit from a political committee. 2 things are important about that. Number 1, it doesn't say affiliation. It doesn't, when the legislature wanted to aggregate contribution limits, they did it only on the make side. When the commission wanted to do it in its regulations, it did it only on the donor side, the make side. The second thing is, I think that the definition of affiliated committees that Mr. Lane pointed to necessarily means that the political committees are each political committee is a PAC who, to join together, those 10 political committees formed an affiliated committee. That's the definition. It doesn't say in the law that you may not accept too much from the affiliated committees.
yeah, I mean, I'm interested to hear what the other commissioners think. This proceeding down this road, and this seems like a very clever donor, right? So I mean, let's not get past that. But I mean, the policy question is well, and the legal question really, not policy, but
I will tell you that, I'm sorry, go ahead.
Is it 10 political committees, or is it an affiliated committee? And I know I mentioned this group of persons idea, but I am sympathetic to the fact that we have 2 different definitions here. So affiliated committee has to mean something.
Yeah, and I think too, we have to look at what our standard is. I mean, we're not the final arbiter. Is there reasonable grounds to believe? I fully follow you, Mr. Chalmers, I really do. I mean, but if you look at this, I mean, this undoubtedly is related or affiliated PACs.
If in fact you, again, this is the same issue that's tripped up previous commissions. There is a lot of desire to look at those facts and a lot of angst about potentially dismissing a complaint with those facts. We are in a 12b6 context. That is a motion to dismiss for failure to state a claim, and we have to look solely at legal issues.
Well, every
This is not an
presumption-
evidentiary one.
Well, first, I don't know if the commission has adopted the Georgia Civil Practice Act. If we have, all facts are assumed true in the staff's complaint, and every presumption is made in favor of the
All of that's
non-movement.
fine, but the question is, did the candidate have an obligation? What is the political committee? Those are pure legal questions. That's not factual. Because Mr. Lane's legal argument is that the affiliated committees is the political committee. That's inconsistent with the language.
Also, I mean, the other argument is that these qualify as a group of entities which made a contribution.
I mean, I see,
I think that's just inconsistent with campaign finance law.
so there's the one, Mr. Lane, in your slide with the list of all of them, you just said that they were made by 10 affiliated committees. I mean, if your argument is that these are all affiliated committees, I don't see the word affiliated committee in 41A. But if you're proceeding down a group of persons, I mean, I can understand the argument. I guess I'm asking, what are you saying?
And I think at this point, Commissioners, given the amount of evidence we have, we can proceed down both paths. That's one reason I include within that slide the definition of political action committee and political committee. Because political committee does, the definition of political committee, which is in 21.540 subsection 6, I think, is used in 21.541A. And as Commissioner Crane, you pointed out, it's a group of entities, group of persons. Now, I know Mr. Chalmers said that, well, it's using the term contribution in the singular. Well, the term contribution is defined in the singular. If you go to 21.5.3, it's not contributions, it's contribution. And then when you read the definition, it talks about transactions that are used to advance a nomination for office, election on that list. So I don't think the plural singular gives you that much cover. And in this one, it's perfectly reasonable for the commission to presume, based on the evidence given, that these PACs were nothing more than alter egos of a group of persons seeking to exceed contribution limits under 21.541.
They were affiliated committees. The law doesn't prohibit accepting contributions from affiliated committees. It prohibits the acceptance of contributions in excess of the limit from a political committee. If we can take the position that the affiliated committee is the political committee, it totally vitiates the meaning of political committee. Because you could always go that route. You could say that the whole concept of affiliation is they're under common ownership or control. How would that ever work? If somebody was under common ownership and control and they had multiple political action committees, and they made multiple contributions through those different multiple political committees and violated the law that way, how the commission takes the position that the affiliated committees that they then become is one political committee, you've completely vitiated the political committee definition.
And I follow that. The question is whether there's reasonable grounds to believe. I mean, I think we have to focus on what is our standard here.
There's no question, but you can't make that determination without deciding in the first instance, may a candidate violate this position at all?
Well, is it a reasonable interpretation that a group of entities made a contribution which exceeded the minimum contribution rate?
No, because to the extent the group of entities...
I'm asking Mr. Lane. I know what you're...
Yes, Mr. Chairman, that is a reasonable interpretation. It's based on the political committee definition that you have contained in 21.546. And that's the term that is used in 21.541A. And 21.541A says that if a political committee, as defined, exceeds contribution limits, then you can punish both the political committee and the person receiving it.
If you don't give 21.541 that reading, Mr. Chalmers, you could never prevent this exact thing from happening.
Sure you can. You can go after the donors. The donors can't do this. That's why the law says the donors may not do. The commission went after the donors.
And meanwhile, someone there in this instance, Mr. Oxendine's office, they're just sitting there collecting 20 and 30 checks from the same individual, and you're just gonna just let them off scot-free?
That is a policy question for the General Assembly about whether that should be the case. If you start looking back, but again,
Then they should have never,
They should-
under that scenario, though, they would have never even put the definition of affiliated committee in there.
the definition of affiliated committees necessarily talks about multiple political committees, right? I mean, I'm sorry, that came across weird, I apologize. The definition of affiliated committees talks about 2 or more political committees. Having defined affiliated committees as committees that are under one common control, if you wanted to limit the candidate's ability to accept contributions from those affiliated committees, wouldn't the law say no candidate may receive more than the contribution limits from affiliated committees, meaning affiliated political committees? It doesn't say that. It says you may not receive more than the contribution limit from a political committee. It's a subset of the affiliation.
Again, we're just going round and round with the same.
Yes, sir.
I'll tell you my personal view. And I do think that this is a policy argument. I find it hard to believe that the word affiliated committee is just going to be defined the way that it is, and that very much concerns me that the way that this has been presented is that they, to me, are affiliated committees, and that's just not in the statute we're proceeding under. I'm equally concerned at the fact that this even happened. But just the lack of clarity in this statute, and the fact that there is a difference between 41A and C, one that puts more than one entity or individual on the hook, and one that doesn't, that uses again different language, has to have some meaning to me. And so I'm not comfortable proceeding or voting in favor of proceeding with this specific allegation. I understand many differences of opinion, but that's just my take.
Mr. Chairman, I have a motion.
Okay, Mr. Commissioner Barman?
I move that the commission find probable cause to believe that the respondent violated OCGA 21-541A when in 2008 respondent improperly accepted campaign contributions in the amount of $120,000 that exceeded contribution limits as the contributions were made by a political committee, and therefore it amounts to a violation of the act.
Okay.
Well, we have a motion. Do we have a second?
I'll second that.
All right, we've got a motion from Commissioner Farnham and then a second from Commissioner Cranville. Any discussion? Okay, Commissioner Thompson.
Mr. Chairman, I'm going to recuse myself on this one because I was the executive director and it was 2008.
Okay. Thank you, Commissioner Thompson, who's recused himself. I'm torn on this one. I think that the omission in the statutory language from affiliated corporation in 21-541 has to be considered. I also realize that at our stage, we're evaluating whether reasonable grounds exist. What happens if there is a split?
There wouldn't be a finding of reasonable grounds.
The motion fails.
It would have to be resubmitted.
Mr. Chairman, may I make one comment? Sure. Appreciate it. If you're torn on what the law is, then the Court of Appeals has told you what you must do. It must be construed in our favor. If there's ambiguity, if this is quasi-criminal proceeding, you cannot move forward with a case unless you're certain that the law prohibits the conduct. As a matter of law, I respectfully request that.
And Mr. Lane, do you want to respond?
Mr. Chairman, I would just point out that The omission of affiliated committee in 21-541 is sort of like the omission in not on the ballot, which we had in allegation 3. I don't think the commission can impose the affiliated committee definition in the 41A. It doesn't exist, just as not appearing on the ballot didn't appear in 41B. So I hate doing it. If it's good for the goose, it's good for the gander argument. But if you look at the definition of political committees, it's groups of persons or entities. You have sufficient evidence to meet the low burden, which is probable cause / reasonable grounds to believe that a group of persons or a group of entities made contributions in excess of the contribution limits, which at the time were $18,800. They donated $120,000. I think you've got enough, respectfully, to find that there's enough evidence to go forward to a full hearing, and at that time we can flesh out the issues better. At an administrative procedure hearing, both sides will have subpoena power. We can call witnesses under subpoena to come and testify. We can have Mr. Watkins come and testify as to what these PACs are, who funded it, how they funded it, when they funded it. So, I mean, it's respectfully, I think you have enough to go forward, and Mr. Oxendine's due process of rights will be protected. He's not going to be found guilty just because you find reasonable grounds.
He should not have to go through that process if the statute is not crystal clear that there can be a violation. And I would respectfully submit it is not at all clear. And the better analysis is candidates do not have an obligation to determine who is affiliated with committees that give them contributions, regardless of the facts of any particular case. That is not an obligation imposed on candidates, it's imposed on the donors.
All right, thank you both. I mean, reading it, I just think that the law indicates that it is a reasonable interpretation. That entities, a group of entities which make a contribution can qualify as a political committee. And in the aggregate, if a political committee makes a contribution which exceeds the minimum contribution limits, the language indicates that it can qualify as a violation. So, any further discussion? So I'll call the question. All in favor of Commissioner Barnes' motion, say aye. Aye. All opposed?
Nay.
Nay. So motion carries. Commissioner Watts, the lone person voting in opposition. And so will that conclude the preliminary hearing for Mr. Oxendine?
Just one housekeeping matter, if I might, Mr. Chairman.
Sure. And I know we'll have an opportunity for public comment. I don't know if we have anyone here that will make public comment.
Mr. Anderson unfortunately had to excuse himself.
Okay.
Just for purposes of perfecting the record, since we will have an administrative procedure hearing, Mr. Chairman, I'd like to move into evidence just for purposes of the preliminary hearing, the demonstrative that was used by the commission, along with a self-proving affidavit from Branch Banking and Trust, which supports the demonstrative evidence we used within our presentation. Also moved into evidence would be Mr. Oxendine's campaign contribution disclosure reports, accompanied by Excel documents, which are the commission's database, which crunches the numbers contained within the campaign contribution disclosure reports. I've already talked to Mr. Chalmers about this. I've given him a copy of all of this, and that's just what I'm looking to.
Okay. And Mr. Chalmers, any objection?
No objection. I haven't looked at it. If it's represented to be what it is, I have no objection, as we said before, to the presentation coming in as a demonstrative exhibit to help Mr. Lane make his arguments. That's not a factual concession on any of the statements contained therein. I would also respectfully request that our PowerPoint presentation also be admitted to the record.
Okay.
And Mr. Chalmers, would it be appropriate if I just print them out at the office and add them to the record?
Oh, sure.
Or do you have copies?
I have copies.
Okay, commissioners, any objection, comments to admitting those into the record? All right, hearing none, I think that will conclude the preliminary hearing portion of our special meeting, and we will now open it up to public comment if we have anyone that wants to make public comment. Okay, seeing that, we will adjourn the meeting. Thank you both, gentlemen. You did an excellent job.